just the right angle. I'm here at the Arkansas State Capitol in the old Supreme Courthouse, here to witness hopefully the defeat of several bad bills. Conduit News has an article about this. Matter of fact, let me share it with you for just a little bit. There are articles titled "With Republicans like these who need Democrats." These are in Senate state agencies, which is meeting in here. There's a whole batch of bills. One is 207 through 211. And this makes it harder to pass initiatives and ballot measures. Right now in Arkansas, you can gather signatures to pass things like tax increases, tax cuts, paper ballots, all types of other legislation. It would require new. Hey, Paul.
Hey, how are you?
Doing great. Hey,
my new wife, Sarah.
Yes, nice to meet you.
This is the guy that he and I get confused. The legislators get confused between the two of us. Just take us for each other.
Well, I'm actually live right now. I'm fixing to record this. I may testify against a little bit because I was, of course, in the ballot initial process. Yeah. But yeah, I'm talking about it right now in Conduit.
Okay, well, fine.
Yep. So there's Tall Paul. We're gonna flip the camera around. You can see there he is.
Yeah. Hey.
See his wife there. And then here's a little bit of the crowd here. But yeah, these bills would make it harder to pass initiatives and ballot measures. I don't know if there's any other chairs. It's already being crowded in here. I tried to come in early to beat the crowd, and I missed it. Almost didn't get a chair. And then, anyway, there's several different regulations they're trying to put. You would have to read aloud names and addresses, showing ID in order to have people sign, making it easier to disqualify signatures. And then there's another one called SB 212, which creates this government department. This is a bill that would call the Document Validity Division, and it's just like the Ministry of Truth or the other Orwellian divisions that would oversee the process of working to disqualify petition to place items on the ballot for a vote that people changes their government. And you can read the rest here. It grows government and reduces freedom. So we're here today. Contact your legislatures. The senators that are here are Tucker, Hammer, Clark, Payton, Flippo, Sullivan, King, and Dotson. They're the ones on this committee. Sullivan and Payton are already here. I know these two. I've worked with them before and passed legislation. Oddly enough, there's a lot of number of conservatives, but also a number of Democrats over here, and they have their own interests regarding this bill. There will probably be an effort to put abortion on the ballot, but these bills won't stop that because all it will do is make it harder for other citizens to be able to do the ballot process. There's Senator Flippo. I actually did some door-to-door for him some time ago. Of course, when it gets started, I'm going to have to stop. So I'm going to go ahead and let this sit here and share people. This starts at 10 a.m. Republican sponsor. Yeah, this is sponsored by Kim Hammer. Thanks, Sri Laura. And I'll post a link to the. Here's my donations link, which is always a good thing to post. And then I'm going to post my link here. Oh, I had it in solo mode, so y'all didn't see the screen that I was showing. What I'm going to do is I got to disconnect the mouse, flip the camera over, set the laptop down, and I need to take a little bit of a break before this thing starts. So I'm going to do that right now. But I will be. So you probably won't hear the rest of me, but you'll hear the committee start. There is another website you can see live streaming, but they don't allow comments. So yes, if you do have any comments about what is going on, be sure to let folks know. But the article that I posted shows all those comments there, and I'll log in with another device so I can access this and share it with other folks. But like I said, right now it's just the starting day. So let me set the computer down if I can, and then I have to take off just a little bit.
Hey, we're talking about I'm not saying all that. Thank you. Right. Exactly.
I'm related to Bob. Well, I like that side better here. I like that side better than this side.
All right.
Hey, what's up, man?
All right. You feeling better?
Yeah, I think so.
And then kill this.
It's going to be interesting to see what happens.
Who you working with? Yeah, I'm just for me. I'm doing some errands, but I'm coming up here.
So how's this going to go? What do you need?
Oh, you are on the live camera, by the way.
Okay. Oh.
I just didn't know.
It's okay.
All right, the chair says the quorum, we're going to call this meeting to order. And first up, Senator Sullivan, we got a minute per minute on SB3. Members, we voted this bill out of the Senate floor 2 weeks ago. There was a minute over in the House that we were just looking at permits with that Senator Sullivan.
Thank you, Mr. Chair. As you know, the bill passed the House and Senate. In the House, we had a small amendment. The amendment to SB 83 makes 2 simple changes. We removed the criminal penalty as an enforcement mechanism. Of course, the civil cause of action remains. And we clarified that when someone successfully sues on a violation of the prohibition of race, sex, or preference, and is entitled to attorney fees, that successful party sues the state, recovery of those fees would go to the claims commission, not the court. So those were two items that were discussed here. Those are the two amendments that were made, and I asked for a good vote.
All right, so we're gonna need two different motions. So Senator Sullivan will backtrack and start with the first amendment, and that's gonna take one motion, the second will pick it up.
To remove the criminal penalty as an enforcement mechanism. And civil action ordinance.
So that concludes the talk. So got a motion from Senator Sullivan, second from Senator Payton. All in favor, say aye. Aye. Opposed? Adopted.
Second, that we clarify that when someone successfully sues for a violation, that goes, for attorney fees or other areas, it goes back to the claims commission, not to the court. I make a motion to approve.
We got a motion from Senator Sullivan, second from Senator Payton. All in favor, say aye. Aye. Opposed? Congratulations.
Thank you, John.
All right. All right, before we start, Ian Rather, Ian, where you at, bud? Ian's patient with us today, he's from Little One West High School. Ian, we're happy to have you here, Dad. Welcome. All right, Senator Hammer, we're gonna start with you, and I'm gonna let you go ahead and present, all 6 of your bills, and then we're gonna stop and go back, and we'll have members question on, going in order from SB 7 through SB 12, and we'll have public comment on each one of them. But for purposes of expediency and time management, we're gonna let you go ahead and present all 6 of them. So members, you're gonna start up perhaps Senate Bill 7. 207.
Mr. Chair, would it be possible, I know we're going to do all of the time, but a couple of things. One, would the chair allow, we would take the Senate bill 210 first?
Yeah, that'd be fine.
And then would the chair allow for Leslie and for Nathan, Secretary of State's office, to sit up here with me? I think it would help.
Absolutely.
Next, but I could ask you questions.
Sure. So, Reverend, what's going on?
Sure. Thanks, Senator Payton, asked this question, but rise, let the light.
Question? I think that's. Yes, everybody's anybody? Yeah, we'll check on that, sir.
I got a ring light.
All right, Bill.
It's over, Senator.
Appreciate the bar, Secretary. Please all introduce yourselves and tell us you're good for the record, and Senator, you're going to proceed with SB 10.
I'm Leslie Bailey. I'm the Director of Elections for the Arkansas Secretary of State's office.
Well, all right, Secretary, you were going to proceed with SB 210.
Thank you, Mr. Chair, and I appreciate you being here, appreciate everybody being in the room. Whether you're for the bill or you are against the bill, I think it's stable. I think some got an opportunity to sign up, some may not got an opportunity to sign up, so I appreciate everyone here. What I'd like to do, Mr. Chair, because of the manner in which we're going to handle the presentation of these bills, Chair, I'm going to read one opening statement that applies to all 6 bills. All 6 bills are intertwined with each other to enhance the integrity process by which initiatives are operated and offered to the citizens of Arkansas. With that, I'd like to read my opening statement. I will go through each one bill with the summary if the chair allows. If you'd like to go that way, and then questions. That's fine. Thank you. Thank you, members, for the opportunity to present the 6 Senate bills addressing the ballot initiative process. We've heard from people regarding these bills, and in fact, we will have on gathering the signatures for ballot initiatives. Today, we may hear from those who vote for and against these bills. I think that within itself should reaffirm that there are 2 sides to every argument. Today, I hope that you will vote on the side of the facts. That is why, through the presentation of these bills, I simply ask that you listen to the facts as they are presented, and hopefully you will see their value absent of the misinformation campaign that is waged against these bills. Each one of these bills helps to safeguard the rights granted in the Constitution. None of these bills undermine those rights. That is why each of these bills have been prepared, working with the Secretary of State's office to ensure that each bill safeguards the rights granted under the Constitution while not infringing on the rights of citizens and the respective groups who want a safe, secure, and integrity-driven process through which signatures can be gathered for the initiative. Also, these 6 bills have been reviewed by our Attorney General's office, and they have been deemed constitutional, and our Attorney General and his team stand ready to defend each of these 6 bills that I present. To that point, the facts about, first of all, Senate Bill 210 are as follows. Canvassers, as the bill is, canvassers may not accept a potential signer's signature until the signer has read the ballot title. The Secretary of State Elections Department, the like organizations, churches, and members of the General Assembly have received numerous reports of citizens that attribute signed petitions that we never support. Instead, they were giving misleading information, such as calling the Divorce Amendment an amendment to protect women for women's health. This will be enforced through the canvassers' affidavit. Only the ballot title summary will be required to be read prior to the obtaining of the signature. I'd like to go on to the next bill, Mr. Chairman, with that brief explanation. Yeah. Okay. Could we go to 2A, Mr. Chairman? Senate Bill 2A. 2A? Yes, sir. Okay. That's agreeable. Senate Bill 208, it requires voter ID for petition signing. The Arkansas Constitution calls for a voter's signature on a petition their vote. In Arkansas, we believe in voter ID, but fail to apply here where it is needed. Only registered voters should be voting with their signature. Only Arkansas residents should be voting with their signature. Last year, the medical marijuana amendment had over 4,500 duplicated signatures. The cause of these duplicates are unclear, but many are likely caused by someone signing their own name, that someone else, family member, friend, coworker, etc., signing their name again. We have no way to prevent this. The ID required by this bill will be the same as what is required to vote. Mr. Chairman, I'd like to want to Senate Bill 207, if I may.
Right after Steve, Senate Bill 207.
Thank you, Mr. Chairman. Each act of petition fraud is Class A misdemeanor, punishable by almost a year in prison. Canvassers are trading thousands of our canvassers each year with signing petitions they have already had signed, cannot legally sign, or accidentally committing other acts of fraud. Largely, this is because people do not see the parking lot petition seriously as government documents, but this bill will fix that error. I'd like to proceed to Senate Bill 212, please.
Senate Bill 212,
Thank you, Mr. Chairman. Currently, the Secretary of State has no real ability to investigate if canvassers are turning in fraudulent documents or if they are violating their affidavit. The Election Division currently gets many reports of petition fraud. Right now, the problem is reported to the Secretary of State or Elections Department. The Secretary of State's elections call for the sponsor, who, of course, denies the fraud. No other investigation happens. This bill establishes investigative authority of the Secretary of State for documents turned into the Secretary of State's office. This bill will not give the Secretary of State authority to investigate campaign finances. This bill allows the Document Validity Division to refer its findings to the correct department if prosecution is necessary, and thus does not infringe upon the duties of the judiciary. Chairman, I would like to do Senate Bill 211.
Perhaps proceed with Senate Bill 211.
Thank you. Names the Honest Canvassing Act, the Petition Protection Act. Right now, the Secretary of State is mostly bound to a honest-based review rather than a review of canvasser conduct. This bill adds layer protection against canvasser fraud by having canvassers swear under oath that they have followed all the laws requirements for while canvassing. This also allows the canvasser to have reciprocal faith protection by being able to fall back on their sworn statement if they are accused after a good faith mistake. This does not add an extra sworn statement like the one on the petition cards already. That is the testimony to knowledge that the signatures are truthful in this testimony of their own conduct. With that, I'd like to move on to the final bill, Senate Bill 209, Mr. Chairman.
Recognized,
Thank you, Mr. Chairman. The criminal signature disqualification. Right now, the Secretary of State reviews the sufficiency on the basis of the petition itself, which might involve bad conduct investigations. This bill clarifies that signatures obtained criminally will be disqualified, period. The burden of the Secretary of State for returning criminal obtained signatures would be the preponderance of the evidence, a standard much higher than the honest faith review of the petition itself, more likely than not. This gives the Secretary of State more ability or gives greater ability in assuring petition validity while holding him accountable for his determination. And that is a summary presentation of all 6 bills. And we'll proceed however the chair would like to direct the question, or however the chair would like to, but I will defer to assistance from the Secretary of State if there are detailed questions about the bills that I can answer, please.
all right. So we'll start with Senate Bill 212, and then we'll just work our way as we start, or 210, excuse me. And then we'll just work our way down from there. So starting with 210, Senator Joe. Okay, right after questions.
Thank you, Mr. Chair. I have several questions, but it's really for the most. I'll have 2 real questions about particular bills, but as you said, Senator Hammer, most of these questions are directed at all the bills together as a package. So I just want to start, because I know we're going to have discussions going with members of the committee and with members of the public, which is great. That's the way the process is supposed to work. And, with the chair's indulgence, I just wanted to start because I think this should be the context for our discussion today. And that is Article 5, Section 1 of the Arkansas Constitution. And I'm just going to read a few lines from this because I think this should be the foundation of everything we discuss one way or the other. And that is that the legislative power of the people of this state shall be vested in the General Assembly, which shall consist of the Senate and the House of Representatives, but the people reserve to themselves the power to propose legislative measures, laws, and amendments to the Constitution, and to enact or reject the same at the polls independent of the General Assembly, and also to preserve the power at their own option to approve or reject at the polls any entire act or any item of an appropriation bill. Next paragraph. First power reserved by the people is the initiative. Next paragraph. The second power reserved by the people is the referendum. If you go further down in Article 5, Section 1, the people remove the governor's power to veto a measure initiated by or referred to. Keep going. There's an increased threshold for the General Assembly to amend a measure initiated by or referred to people, 2/3 threshold rather than the simple majority it takes for us to overrule our own legislation. There's quite a few more that I won't read. The last one I'll mention is there's a subsection of Article 5, Section 1 that's titled Unwarranted Restrictions Prohibited. And it says no law shall be passed to prohibit any person or persons from giving or receiving compensation for circulating petitions, nor prohibit the circulation of petitions, and this language is important, nor in any manner interfering with the freedom of the people in procuring petitions. So that's foundational language for our form of government in Arkansas. I just want to mention that before we get started. My first question is, there's 2 phases to a ballot measure process. The first phase is gathering signatures to get something on the ballot, and the second phase is when people have decided to vote on it, it's making it to the ballot. What do you view the purpose of the first phase, the signature gathering process? What's the purpose of that process?
I'll answer it from a legislative perspective and defer to the Secretary of State to add on if that's all right. You said, Dr. Of course. I would like to address the opening comment that you made, though, in that I would like to also say I do not believe that any of these 6 bills violate the Constitution or that which you've read regarding the constitutional framework under which petitions can be gathered. Otherwise, I think we would have been told that by the Attorney General's office, and I do not think he would be ready and his team to defend these should these be taken to court. So I would liken it unto, attorneys in the room. You have 2 opinions, and someone else may have decided what they view as right. interfere with anybody who wants to operate under a fair and a process that has a high level of integrity with regards to gathering signatures. It would probably be just a simple, we agree to disagree, but I do not take the position that any of these 6 violate the ability for citizens who want to operate in a above-board, integrity-driven process to gather signatures.
Okay. So I understand, and, you know, I know what we're gonna agree, disagree on, that's okay. That's part of democracy. But my question really is, I understand you want the signature gathering process to have the utmost integrity. Obviously, we're gonna talk about that. But I'm kind of taking a step back from that, and from a big picture standpoint, asking, what is the reason why we don't we just put it on the ballot straight away? Or why don't we have, well, what's the reason for the signature gathering process in the review?
I think it's an opportunity for citizens who are wanting to get an initiative on the ballot for the overall citizens of Arkansas to be able to vote on, absent of legislators not taking particular issues up, or the citizens disagreeing with what we as legislators have voted to do. It's an opportunity for them to have a voice in the process. And much like we as legislators want to make sure that the process respects individual opinions, we also want to make sure that every step of the process is absent of anything that may intimidate or prohibit citizens or mislead or misinform citizens by gathering a signature under a false pretense.
Okay. Fair enough, and I think, you know, my layman's version of what the purpose of the signature gathering process, I think, is similar to what you just said, which is that it's really to find out if enough Arkansans care about this issue for everyone. And like, just to look at you. So that's the purpose of the signature gathering process. Might be not what you're now, but I think you said something not too different from that. So my next question is, and I know your view of these bills is to protect the integrity of the signature gathering process, and that's a valid goal. And so my next question is, what are the harms that you're trying to guard against?
Well, I think on merits, as mentioned in some of the summaries given on each one of them, that they are all driven out of issues that have been brought to the attention of either legislators, Secretary of State's office, and just various avenues in which these issues have been brought forth, and these are proposed solutions to those that I think I captured in each one of the opening statements. Or it possibly addresses something that potentially could be used in a manner which would jeopardize the integrity of the process. However, the majority of these are the result of things that have actually happened.
And I heard you say now, and in your own comments, that maybe 2 of the harms that you're trying to guard against are someone being misled and signing something they don't intend to sign. Right?
I'm sorry, say again, or I heard the first part.
So one of the harms that I think you're trying to guard against is someone being misled and signing a petition that they wouldn't have otherwise signed.
That's right.
And then another is maybe an invalid signature.
That's right.
And I recognize those are harms. Those are things that we want to try to protect against. In my view, and those are kind of on one side of the ledger, the way I see this. And then on the other side of the ledger, there's another harm, which is the people of Arkansas not being able to get their proposed ballot marriage on the ballot. We kind of have to balance those against each other. Do you have any thoughts about that?
Sure. I think that if the issue is that high of a priority to any group of individuals, regardless of whatever side the issue they may be on, that each should want a process where, just like we have coined the phrase that every vote matters and every vote counts, I think that ought to be carried down to the petition process. That's why we work so hard to make sure that our elections are secure and make sure that our elections are driven by integrity. And I think that begins at the point that you ask somebody for their signature feel equally strongly as I do not see where any of these 6 bills will prohibit me from doing that. In fact, if anything, I think it will secure the fact that if I am able to get those signatures that are legal signatures to be on those forms, I have built an even stronger case because given an opportunity to speak for this bill, you will hear testimonies from individuals that will bring real life stories to the exact 2 points that you just mentioned if we are able to get that far.
Okay. Would you mind, I got to start the exact question on that. Can you go back and finish up your current question and then jump back in?
Yeah, well, let me ask maybe 2 more.
Sorry, do two, yeah.
So this may be, this is not a great analogy, but I've been thinking about this in terms of our traffic laws as an analogy, because we know that on one hand, people need to get around, but we also know that there's an inherent danger. We know people are going to die in car accidents as a society. Now, we could put a stop sign or stop light at every intersection. We could do that. We could prohibit cars entirely. We know for certain that would make people safer. But the restrictions are so severe that it makes driving by a car useless. I don't know how long it would take you to get to the state capital from around Sloan County if you get those 4-way stop sign at every intersection. You would be safe, but it would be kind of pointless. And do you have any thoughts about that? There comes a point where, in my view, if you look at it, we passed laws to make the signature gathering process more difficult in every legislative session since 2013, and sometimes several times a session. And if you look at any one of these individual measures by itself, maybe it's fine. But there comes a point where it's death by 1,000 cuts, and it becomes too spotty. And the more you add on, I feel like we're getting closer to the point where, yeah, you can make a legitimate argument that it's going to be more secure. But it's like putting a 4-way stop sign at every intersection, where there's no point in you getting in your car and continue driving. So, anyway.
And I respond, I think that comes down to an individual's understanding of the value of life in regards to your analogy, number 1. And number 2, I do not subscribe to any thought processes that is less than 100% accurate, whether that is at the voting box and the results are less than 100% accurate. I do not subscribe to the mindset that says that is acceptable. I am willing to accept less than 100% accurate, especially when you have the ability to know that the vote outcomes are 100% accurate. I think that's the greater danger that we face, is that we begin to recognize that there are problems and we are either too afraid to address them or we are intimidated out of addressing them. And I think that's what these 6 bills are brought forth to do, is to say this intersection that we are at in the petition gathering process doesn't need a roundabout, it needs a stop sign. And we're putting down 6 stop signs.
Where do I want to go, Mr. Chair?
Last question.
So I think one of the mistakes, and again, I'm speaking generally, big picture terms right now. I think one of the mistakes that the legislature has made when passing these measures and referring these measures out to people over the last decade is that we have conflated the 2 separate phases of this process. One is the signature gathering, and one is when the people of Arkansas vote. Now, in my view, when the people of Arkansas vote, I want there to be exactly 0 fraudulent votes cast. And I think there's real harm to the people of Arkansas if something passes, and the only reason it passed is because there were votes cast fraudulently or invalidly. And likewise, I think there's real harm to people of Arkansas if something would have passed, but for some fraudulent votes. I want there to be 0 fraudulent votes in the ballot. To me, that's a separate process from the signature gathering process. And the harm maybe some people signed who shouldn't have signed. I'm not for that, but the harm is not at the same level. Because the downside is maybe there were 85,000 ballot signatures instead of 90,000, or 87,000 instead of 90,000. And so really the only harm is that people vote on one more measure. And the damage done to the people is not at the same level. Do you have any thoughts about that?
I respect you. We like each other. I cannot, on any time I'll spend on this planet, subscribe to that mindset that allows for a lesser interpretation of the value of signature going on a piece of paper that has been signed as an affidavit of truth, notarized. And there are 4,500 examples that show that those 4,500 examples misrepresented and also for somewhat practical purposes may have canceled out another 4,500. I want every signature to be valued. I want every signature to count so that make the best argument win through the most fair process established.
Thanks, Senator Tucker. Senator King, you're right after that.
Okay, Senator Tucker covers some things, and some things, one thing I want to compliment you on, Mr. Chairman, if you would
Oh, there's not Senator Ham, sorry.
Yeah, but I'm making sure you know that I'm complimenting.
Well, me, very glad to be here, Senator King.
So, you understand our mayor, sometimes, unfortunately, for everybody goes out in front of the public, and see what goes on behind the scenes. But, so a compliment on breaking these apart, not doing novels. And I know that is, so I appreciate that, because some of these ones, the vote I need one, it's not, or the vote I need. But, so, and I'm not going to get into some of the other questions, but the big thing is the cost part of this. When you do investigations, and somebody's been on election commission, when an election third, submitted, be part of the process, you have a signature gathering process, you're talking about one person, looking into several, maybe thousands or hundreds of, possibly something wrong. There's no cost estimates about there's no fiscal impact statement. I know that's hard to guess because you really just don't know what you don't know. But the overall scheme of our budget, the Secretary of State's office is essential services fund, so you're going to get funded your appropriation. So, these investigations, any estimates on the cost of the extra officers, well, these, this is the overall of it. There's just no cost to any of these things. And I know it's a hard guess, but there needs to be something.
Sure. And Senator King, I appreciate the question because that was one of the concerns out there. I'm going to ask the Secretary of State's office to respond to that, but I would say that one way in which we can measure cost is through whether or not additional staff would need to be added. I think that is a direct driver to the cost, and I'd like to yield to the Secretary of State's office to address your question if you're okay with that.
We're not looking at adding any additional staff. We already go through a lot of the documents, so we would just be taking some additional staff that we already have to go ahead and further look at those past what the election division scrutiny has done. So I think you hit the nail on the head that it is a little hard to determine because you don't know what measures might have more fraud or might not have any fraud. So I think that we have looked at it from trying to absorb it within our budget with no additional staff with the people that we already have.
And I mean, that's the thing that I think that needs to be out there is how much money are you going to be looking at? Because, as I said, we just don't know what we don't know. I mean, we're talking about, every time an agency comes in here, I've been here a while, unfortunately, that means that sometimes you learn things. They say, what we're going to do with the existing staff, and you have a law, and then all of a sudden we have, we don't know, and with the Secretary of State being essential services and being funded at that amount, it's very crucial to at least look and see and have targets, because this existing staff, based on what I know, get involved in elections. You know, the potential of it could be a lot, and if you're short-staffed and you don't have it, then you come back and say, you know, we don't have the money, we thought we did, we didn't know this. So I think of having allowances with our budget to say there should be a separate appropriation bill, there should be a separate target that potentially, and understand, with civil services, you don't have that. Secretary Martin, to me, as the Secretary of State, did not get a lot of credit, because he managed to concisely budget down, and with that extra money, we were able to buy voting machines to do things to turn back and have partnerships with the county, because he did that. And that is my concern about a lot of this. Even though there's some of this, I'm with Senator Tucker. I mean, I just feel like we're moving the needle away from the citizens initiative. I want to make it far easier for citizens, as long as it's done correctly, to be on the ballot. We turn this into a rich person's game to get things on the ballot.
Amen.
But I think the cost part, I think that's crucial to know, because we can't budget right now. And I say this on the budget part, as soon as you know it will come. Education spending is going up right now. Whatever you want to say about your degree. Medicaid's not going to go down. Special interest and a lot of things are not going to lie back. So I'm just, corrections, everything that we're doing right there, this is not a singular issue. Like I said, we're using simple services. Right now, revenues are going down. And it behooves me of like how things today, that we are not looking at our overall spending. Whenever your revenues are going down, they're down 5% the last few months, they're going down. And overall, and this is not just Secretary of State, it's everything in state government right now, and spending is going up. So I would appreciate like at least some type of target or some type of separate entity, because even though I'm sure you're being honest and well-intentioned about what we're going to do with citizen staff, you get out there and have a bunch of petition gatherers. I mean, I went out and busted a bunch of illegal voter registration fraud in East Arkansas 12 years ago. I probably spent 4 or 5 days on my own traveling around to get those out there. I can tell you with existing staff that that's problematic with the cost. And I'm not going to get into these questions. Thanks.
Mr. Chairman, yes. These, well, as testified, no additional staff will be added, number one. Number two, except for the one bill where the question is probably generating the concern, all the other ones have no additional cost to the department. And then the third thing I would say is this: if testifying today, if they were to come back and ask for additional staff, although I think historically they've been able to absorb things that were perceived as having an increased cost that have not come to fruition, I think that's where we would say, do you remember what you said, and we would hold them accountable to that. There's enough future generational legislative presence in this room to remind us of that for the next 2 to 6 cycles, or 2 to 6 years.
Thank you, Senator. Thank you.
Thank you, Mr. Chair. Senator Hammer, I do appreciate that they're short bills and that it's broken up, because the legislative process is very important. But, you know, I'm maybe a little more paranoid than some of my colleagues down here, but my constituents expect me to read every word of every bill and know exactly what it's going to do. And even though I may be on board for the objective, it matters how we get there and what the language is in that bill. So I appreciate Senator Tucker's question about why do we have the petition process. And I agree, it's to demonstrate that there's a general consensus that something needs to be done about a topic. But when we do a ballot initiative or a constitutional amendment and we're gathering signatures, that language has already been crafted. And it has not been through a debate and a legislative process like what we do here, and every word questioned. The title gets questioned, and they're gathering signatures. But Senator Hammer, do you believe that a signature on a petition to put something on the ballot is of more weight than a vote at the ballot box for or against that initiative?
I believe they each need to be treated with equal integrity, because what is signed on an affidavit, which we have verified that there are problems in the signature gathering. I think they each carry equal value. The reason I would say that is because it is a gateway to the ballot box. And why would we want to delay the process, or why would we not want a process that is as thorough and as strong, and yet as fair and as transparent in the gathering of that signature? Signatures ought to be treated like heartbeats.
So let's say you have an election with 100,000 people to vote, and it's going to take 50,000 plus one to pass that measure. But it only takes 10,000 to get it on the ballot. I would argue that meeting one of 10,000 makes your signature worth 5 times what your vote is worth. Because it takes 50,000 plus one to pass it. Well, it took 10,000 to put it on the ballot. That's a 5-to-1 ratio. And so we require identification. We keep voter rolls. We try to make sure that whoever votes in favor or in opposition to a measure, that it is a valid vote. We're very concerned that we have accuracy in the county. Why wouldn't we want to be just as concerned that we have accuracy and identification in the ballot process? I have the signature area.
No, I would agree. I think we are saying the same thing. Maybe I misinterpreted your original one. I think we're arriving at the same destination. I agree. It is exactly what you said.
Well, and you probably misinterpreted some of my questions because I'm trying to look at both sides, and I'm gonna have questions that sound for it and some questions that sound against it as we get into this. This is the legislative process. That's what it is. And that's what the ballot initiatives lack, in my opinion. And that's why we need to be concerned with preserving access to the ballot when the people have a grassroots effort and there's overwhelming concern to fix something or to pass something. But I'm very paranoid about the content of the something, because when you go out and advertise, you get a sound bite or two that wins or loses votes. And I'm expected to read the bills, but sometimes I don't trust all of my colleagues to read the bills, and I certainly don't trust all my neighbors to read the bills. And the reason I don't, I do trust people's integrity to want to know what's in it. But we have a legislative session going on right now. I've lost track of how many bills are filed. I know I've already reached my capacity to read and study and vet every bill before me, and I'm just in one of 10 committees that handles a 10th bill. But with all that said, if we go to the ballot box and we have 25 citizen-led initiatives on the ballot, how much time is that going to take for people to vote? Let's just assume that they've studied every word of every initiative, but there's 25 or 30 of them on the ballot. We have to, at some point, consider limiting that access. So, as we look at the scale or the ledger that Senator Tucker talked about, you have maybe more than 2 sides to the scale. It may be more like a disc we're trying to balance. Because I do believe that we need access. I do believe we need people to do their due diligence, and I appreciate the fact that one of these bills requires people to read at least the title and know what the title is. But we also have a need for brevity. I mean, I would like to limit how many bills can be filed down here in a session. And if we need to have another session, let's have another session, but I mean, there's a limit to how much due diligence we can do on 2,000 or 3,000 or 10,000 bills. We do need some brevity at the polling place. So there has to be, I mean, I've been trying to pass a used car sales tax exemption for all my time down here. I'd love to run I think I have overwhelming support. I could probably get the signatures and get that on the ballot.
Yes.
But we can eliminate every tax if we're not careful, right? So, Anyway, I guess I'll have some more to say later, but I'll get out with you. Senator Hammer, I just want to know, are you trying to eliminate ballot access?
Not at all. I'm trying to protect the process by which the ballots have additional value by knowing that each of those signatures on that ballot initiative has been well vetted. The public has had the greatest opportunity to be informed and not misled as to what they're signing. Now, I'll give a shout out to Senator Tucker. I don't think I'm on this. You can straighten me out. I think he's running the bill where those initiatives are going to be put on the Secretary of State's website. Hey, I think that is a great thing. But also at the same time, I think these are sick bills that if we are going to reach out and touch each piece of the ballot initiative process, then let's make sure that each piece that touches it brings value. I think his brings value. I think mine brings value.
I mean, I've had a lot of emails that say you're eliminating ballot access. That's not your goal.
No, sir, and I'll take advantage of this opportunity. I don't think all these out-of-state calls that have been blowing up my phone, telemarketers, it always strikes me as interesting. Why do people out of state get so interested in what's happening in our state unless there's an underlying ulterior motive?
Thank you.
Thank you, Senator Bacon. Senator Tucker, you were up next, and you're not her question.
Thank you, Mr. Chair. So, I don't want to pick up, a couple more big picture questions before we dive into the language. I appreciate some of Senator Payton's comments because that's where I was going next, really. Under the Constitution of Arkansas, we got two sets of lawmakers. One is the root, Senate of the state, 135 of us in this building. And the other is every citizen in the state. They're lawmakers just like we are under the Constitution. And the corresponding act for us as legislators is filing a bill for them, for the people to gather signatures and get something like that. And so, you know, I sort of wonder if we should put some restrictions on legislators filing, if we're concerned about, because that's the analogous part of the process. If we should put restrictions on legislators filing bills, just so we have the same restrictions that we're placing on people to enact laws.
Well, I would say that if you'd like to introduce that piece of legislation along with Senator Payton, that'd be a good bipartisan bill, and we'll see where it goes.
And I would just say too, Senator, you know, that to me, signing something saying that people should, you're not actually making a decision when you sign a petition. All you're saying, other than to say that people should vote on it, you're not casting a vote. I've signed petitions of ballot measures that I would vote against if they were on the ballot because I thought they should be signed on which is so it's really a separate question to me. But anyway, for what that's worth.
There, Tom.
Of course.
When I put my name on something, whether it's a credit card receipt or a check that I write or a bill that I sign into the consideration, we do so much. We pass laws to prevent somebody's signature from being misused or misrepresented for the intent of which it was presented to be asked for. I fail to see why we shouldn't bring that same standard that we live with every day of our life to protect that signature to the ballot initiative process.
But and y'all are welcome to this as well, it's already illegal to sign someone else's name to a petition, correct?
Yes, so we have examples of that having happened.
Right, and so that's a question of enforcing the current law rather than passing a new law.
So I have to say that again.
That would be a matter of enforcing the current law rather than passing a new law.
It would be a matter of
Let me just go in over here, and that's for posting audience, if you could please, keep your silence here. Everybody's gonna have their opportunity to speak when we sign up, for and against these bills. It does interfere with the members' ability to hear the questions or hear the answers. So keep that silent. We appreciate that. Thank you.
That ability is already there, I think, by the evidence of the fact that that use continues to happen, that what is being added does not take away from that, but I think what it does is provide that additional ability for those who do it to be held to a higher standard of accountability.
How so? What's the higher standard of accountability?
Would you mind which bill you're referencing?
Well, I don't know how many of the bills, but I'm just curious about your statement that it's a higher standard of accountability for signatures. And I guess I don't understand how that is. It's already legal to sign someone else's name. It's already illegal to sign your name more than once, correct?
It's already illegal to sign your name more than once, correct?
So what is it making a higher standard of accountability?
As it relates to the bills that are before us,
Yes,
I think that as you look at, and if you have one particular bill that you're ready to discuss about, or you just speaking to the overall bill.
well,
I think that probably one of the arguments that could be made, or one of the things that legitimize the necessity for all 6 bills, is that what it does is it closes any unaddressed loophole that is currently being taken advantage of.
what loophole is that?
I'm gonna let the attorney answer or give the question.
Senator, we agree with you that it's important to balance the interests of the people to have their voice, but also for the petition process to be secured. We feel like these bills help balance those district interests and secure the petition process. I think we want to get into specifics of how they do that. Right now, clearly, there are issues with the process, and these bills are aimed at fixing those issues. So I think it might be better to, kick it over to Director Bellamy to talk about some things that happened and how these fix those problems.
Let's just talk about each of the bills. And I have a ton of questions on each individual bill. For what it's worth, Mr. Chair. So I'm in the same order you did, Senator. We'll start with SB 210.
Sure. Well, still,
So this bill requires a ballot title for the person who's going to sign either to read it or to be read aloud to them, correct?
the summary.
Are you aware that some ballot titles can be 600 words or 800 words?
I'm aware that some of the ballot titles could be perceived as lengthy. I'm not sure that the ballot titles are as lengthy as the ballot itself. And so this is best effort at gathering what would be the summary.
Did y'all time how long it will take to read any of the ballot measures that signatures were being gathered for the last election cycle, just to see how long this would take to gather an individual signature? Or some of those times?
I read over some of the ones in the last 2 cycles, and the part that we were wanting to read. The most lengthy one, that I had was referred from the legislators. And it took me right around probably 8 minutes to read it and be able to, comprehend it.
I think, if I may, I think one of the things that drives the necessity for this is the fact that we have evidence of people that were asked to sign something and it was misrepresented as to what it truly represented. And I think if we ever did want the public to testify, you will hear someone who would give testimony. So one thing we want to do is, yes, will it take 8 minutes? Yes. May take 2 minutes, and I think will cause people to make sure they tighten up their definitions or their summaries. This goes through, but again, I'll go back to the argument to the principle that anything of importance that you're assigned, whether it's your papers, it's your house, or whatever the case may be, the most important things is what you're putting your name online that you would like to see put before the citizens to vote. So 8 minutes or 8 seconds, the principle of all price equals the time it takes to read it.
I hope when I check out at Best Buy, they don't read the terms and conditions out loud before.
Senator Tucker, I want to commend you. I know this is like Senator King and Senator Football. I want to commend you because you have just addressed the concern that you have because you are going to run legislation to put it up on the website where any voter that wants to really do due diligence can read that before it's ever placed. So I want to commend you for running that legislation. I'll be glad to vote for it.
Thank you. I'm going to run an amendment. Maybe I can put you on as a co-sponsor.
I'll put you on mine if you want.
Senator Tucker, can I ask you, you've got a follow-up question to that, but if not, I'm going to Senator Sullivan that's got some questions. So.
Yes, yeah. So let me finish with this bill. Yeah. Thank you. So I really have two follow-ups to what you just said. Well, I sort of made a joke about one, like the terms and conditions at Best Buy. You're signing your name when you do that, correct? Just like you are. So anyway, one specific question is, do you think having a 500 to 600 words of legal reason read aloud to a person will help them understand what they're voting for? I guess you do.
I think what it will do is make for a more educated individual who's going to sign something, and the burden of responsibility is on them to choose whether or not to read it yourself online as you're doing, or at minimum, we need to make sure that there's no set. Because the one thing about reading it is not only so that the person who signs it understands what they're signing, but it's to hold accountable the person who's asking that person to sign something, and that they have not misrepresented the facts, of which we have cases to prove that the facts have been misrepresented. So it's a dual-edged sword. It holds the person accountable in signing it. It holds the person accountable who's asking for the signature. The best way to do that is clarity of saying, this is what you're about to sign.
Did y'all work with any, here's my other question, did y'all work with any signature gathers when we were putting this bill together?
We had input, but direct meetings.
So it's really just two more questions on this particular bill. One is, we know it's going to take more time, correct? It's so that you, go ahead. I mean, I don't want to cut you off. That's not really my question. I think we know it's going to take more time. Feel free to comment if you want. The question is, I'll just go ahead and ask you to respond all of it. The question is, did you consider extending the amount of time that people can gather signatures in order to account for the fact that each individual signature is going to take more time?
I think that could be, a debate could be had under a separate bill. Again, I think what you just stated was not necessarily that you're in opposition to the concept. You're maybe expressing opposition that it may slow the process down or discourage people from signing because they don't want to stand there and have it read to them. And if a bill was ran to extend the length of time where the signatures could be gathered, I think that would just reinforce that this would be the right thing to do.
Go ahead.
Senator Sullivan just jumped out, so.
Oh, you can jump out.
Yeah. Not literally, jumped out.
Sorry.
If you need the break, Senator.
So is it not already a crime to misrepresent what the petition says it does?
Yes, it is.
So once again, that's really a matter of enforcing the current law rather than adding a new law.
The way I would address that question is that it is acknowledged that it is illegal to misrepresent something. So if we know that it's going on, which we have evidence that it is going on, would it not be better to prevent it from going on by bringing legislation forward that will eliminate so that less people would be charged with the crime, but those that are being asked to sign would have a greater level of protection by having this afforded to them. We are trying to prevent it from happening by doing these things, whereas one mindset is let it happen and then we'll see who gets caught afterwards.
There is already mandatory training for all cameras. So one thing that Senator Payton said on the floor last week, which I really liked, is chapter and verse. It's good to go back and see the context of things. And some of these bills, so in 210, for example, it adds a new subdivision 10 to Arkansas Code 7-9-103C. And so I went, looked up, because it doesn't have a whole section for it now, so I've got 7-9-103C here. And what that list does is it says a person who commits a class A misdemeanor, they do any of the following. One of those things is what I just referenced. Number 6 is knowingly misrepresents the purpose and effect of the petition for the measure. So that's already a crime. I think we passed that 2 years ago. I voted for it, just for the record. So, what this does, this new subdivision 10, it would make it a crime to accept a signature without making sure they've read the ballot type or reading it aloud. Correct?
That's right.
Are you concerned at all about the burden that will, especially volunteers, people who are exercising their First Amendment rights to gather signatures to put something on the ballot that will turn them into potential criminals if they don't read something that can take up to 8 minutes every time they collect a signature?
No, Senator, it's just a good faith requirement on the canister where the paper that the person reads it. So if somebody acts like they read it, but they really don't, as long as they do that, effort was made by the canister, no issue with that canister.
All right, if this bill passes, and you just have Arkansans volunteer exercising their First Amendment rights, and it'll do something with each signature that can take up to 8 minutes and they're a potential criminal under the law. This bill passes.
This bill doesn't change the fact that if a canvasser commits fraud or misrepresents something, that they've committed a crime. That already exists. So this bill wouldn't change that.
I understand that. That's not my question. My question is, if they don't do an affirmative act, specifically reading aloud the ballot title or having them read this the person who gets signed, an affirmative act up to 8 minutes every time they collect a signature, then they're criminal under the law. This bill passes.
I would respond by saying you're using an 8 minute. I don't know that is, number one, the average time. Number two, I think, as used the example that Senator Payton did a while ago, balancing the scale. We have examples of individuals that have signed things that were misrepresented. How are we going to address that so that people are not signing something that a petition gatherer purposely or may not purposely has misinformed the person? How do we address that problem? What is the way to resolve that problem so that both the one gathering the signature and the one that is signing is going to be protected? It's about protecting both ends of the process, and the only way to do that is to make sure that they are educated in what they are about to sign. To me, this would help prevent somebody from being falsely accused, and those that want that type of protection should not be objecting to this.
Approximately what percent, if you, I mean, you may not know, but if you can give an estimate, what percent of signature gatherers are misrepresenting what the petition is about?
Senator Tucker, I don't think I could put an actual number on it. I know that my election library gets hundreds of calls every petition season about being told, that the abortion one is about, women's health, or whatever the marijuana one is about, there's people that call it, want their names removed from the petitions because they come to realize that it was not what they were told. So I would think that, this just mitigates the possibility of fraud so that the voters understand what they're signing, and it also protects the good canvassers, because the ones that are doing it right.
So, I don't know how many signature gatherers are misleading us to what petitions. Now, for the purpose of this next question, I'm just gonna say 5%, even though I believe that number to be high, but I'm just gonna use that for this hypothetical. Senator Hammer raised the question, how can we address that if people are misleading? And my question is, would it not be better to prosecute the 5% of bad actors for committing that crime that's already on the books than imposing a new obligation on the other 95% who are doing it the right way?
Well, that's one mindset. The mindset would be this: why would we want to leave a system in place that is going to charge 5%, that's going to tie up our prison system, make us have to build more prisons, put more people in a position to have records on hand? That's like saying we need a stop sign there, but we're going to take a chance that 5% of people that drive through it aren't going to make it, and that's a calculated risk. I don't think we ought to be in the business of calculated risk. What we ought to be in the business is making sure that people avoid those situations either by accident, unintended actions, intended actions, but also to the protection of the person that is signing it. So I subscribe to the mindset that if you're going to initiate a process, your volunteers, it's your responsibility to train your volunteers, and people will know what they're signing up to do. And if you've got a really good initiative that you want on, you're not going to have any trouble finding people that want to do the right thing. If you don't, you might have problems, and then maybe you need to think about the initiative you're trying to put forward.
I'm just worried about finding people. People think they're going to say they're going to be signing the crime. And I would also say that if we had one, if we have one as well, but if we have one example of a prosecution conviction on the books of a signature gathering misleading, that to the extent that's happening out there, which is subject to debate, to the extent that's happening down there, I think it would go way down. We're not going to have continued misleading representations where you're going to be putting a lot of people in prison.
I think that when you take a look at leg audit and what we experience, this type of crime versus prosecutors having to spend their time going after other crimes such as murder and the severe crimes, we hear it echo through these halls all the time, that if they have to make a choice, and it is delegated to the local prosecutor to make that choice, I think you have to factor that into consideration. Do I agree with that? I think that's the way it ought to be. I'm not saying that I do, but I'm saying the reality of the argument is when you sit through enough meetings down here, especially with the leg audit, you hear these kind of things. And this, again, in the absence of a prosecutor either having time, interest, resources, that should not be a reason why we let it go on, so that hundreds of calls that are evidence to exactly what we're talking about continue to come in if we can minimize that.
The current crimes not being enforced, I don't know what's going to cause this one to be enforced, but anyway, I'll move on to the next little sentence.
Senator, based on what you just said, there should be no fear about this bill.
Senator 208, this is the voter ID, voter identification. I just had a specific question about a line in Article 5, Section 1 of the Constitution. If you go to the verification subdivision of Article 5, Section 1, it says, all signatures shall be in the presence of the affiant. That's the best of the affiant's knowledge and belief. Each signature is genuine. And that the person signing is a legal voter. And it closes by saying, no other affidavit or verification shall be required to establish the genuineness of such signatures. So is it not possible that requiring someone to provide photo identification is another verification being required in violation of that subdivision of Article 5, Section 1?
Would you, I want to make sure before I respond, would you state your concern again on that? And you're on 208?
Yes.
And what page where?
Page 127, just where you require the photo identification.
Okay, go ahead.
Y'all, do you happen to have a copy of Article 5, Section 1 that
I'll start it.
we, so I'm just gonna reread. If you go to Article 5, Section 1, there's a subdivision called verification. And it says, I'm gonna paraphrase, so I don't have to reread the whole thing. Then I'll read the part that. It says that you have to make sure that you know that the person is, that's a legitimate signature. And then it says, no other affidavit or verification shall be required to establish the genuineness of such signature. My concern with this bill is that you're adding another affidavit or verification requirement to establish the genuineness of the signature in violation of this language in Article 5, Section 1.
Senator Tucker, I don't want to get too much into legal back and forth with you. I think the simplest way to explain our stance on it is that we believe that signing a ballot petition is a vote, or voting, the same as voting, in the same way that it's legal to require ID verification when someone's casting a vote in the ballot box. It would be legal here before somebody signs. So
I believe that language was amended when the people amended the Constitution to require a photo ID in order to vote.
I believe that requiring identification verification as it's laid out in the bill prior to somebody signing a petition is legal and constitutional.
So with this in combination with the previous bill that we just looked at, how long do you think it takes for someone to provide a photo ID and verify? How long do you think?
Well, I go to the bank, I cash a check at a bank that's not, my bank, I gotta pull out my photo ID, go to the doctor's office, they want to see my photo ID. I go anywhere where legal business is being conducted, I have an ID on me. I don't think it's out of the realm of reasonability that a person is walking around with a form of ID.
My question really is in combination with several two changes. I'm curious if you all ran the numbers estimate. If you add up the time that all of these would take to gather a signature, what the total time per signature might be, if you all ran the numbers.
No, I didn't run any numbers on that. I mean, it takes mere seconds for me to pull out my ID to get my prescription, to go to the doctor, to cash a check. I don't really go anywhere without ID. I don't think most people do. Even one of the questions that was posed to me was the festivals. Well, at a lot of the festivals, you might be talking about an alcoholic beverage, or you'll have your ID for that. So I don't think that it's gonna cost any time to pull out the ID, sir.
In the constitutional amendment that requires photo ID in order to vote, there's a cure in that amendment, for not having your ID correct. But I don't see a cure in this bill.
There is not one.
So if you don't have your ID, there is no cure.
That's correct.
Okay, moving on to Senate Bill 207. Well, one last one on 210, there's also criminal liability attached to that, correct? So if you get a signature without requiring a photo ID, as a signature gun, then you're subject to criminal liability, correct? That's for paid and volunteer captures?
There's criminal liability in misrepresentation or fraud on the part of the canvasser already existing. This would not change that. These bills wouldn't change that.
But it adds a new provision for criminal liability too.
It adds a provision that makes it harder to misrepresent or commit fraud in the petition process.
Okay. And that applies to both volunteer and paid captures.
Yes, sir.
Okay, Senate Bill 207. This bill requires the canvasser to notify the person signing that petition fraud is a class A misdemeanor. Correct?
Correct.
Are you concerned that this might intimidate anyone and prevent them from signing if they think they might be committing a crime by signing?
What it's gonna do is it's gonna create a responsibility on the one that gathering signature to inform them, but have reasonable ability to assure them that they will not be because of everything that's being required in these bills.
This will take a bit more time too, correct?
Probably about as long as 5 seconds that I want to make you aware that signing this fraudulently could result, I think, in about 6 seconds.
And this also adds a new section for criminal liability if the cancer does not do this.
I believe that's what's on page 2.
Okay, so we'll do 12. Would this authorize the Secretary of State's office to investigate nonprofits doing voter registration?
You say that again, that was a echo effect.
Of course, I think I moved away from the mic a little as well. Would this authorize the Secretary of State's office to investigate nonprofits doing voter registration?
It would authorize the Secretary of State to be able to investigate documents that were turned into the office, I believe under chapters 5 and 9. So, Senator, if they do so under chapters 5 and 9, I guess.
Okay, so why is this? Is the Secretary of State not already present on the authority to conduct investigations?
The Secretary of State has the authority to look into matters currently, but this bill would offer some tools for the investigative process that the Secretary of State doesn't currently possess.
I moved down to subsection D, I'll start on line 26. Yeah, this says that the person is not excused from a subpoena, even if it might incriminate them, correct?
Well, as you know, Senator, if someone's compelled to testify, then because of the compulsion, then what they say can't be used against them by the state. So if that authority was used, it would be because it was deemed that their testimony was valuable to the security of petition process or something like that. And what they said wouldn't be used against them, could not be.
By the state. Well, we can't make that guarantee on behalf of the federal government, can we?
Well, it depends on the type of hearing or what context somebody's testimony was compelled.
Or do you have any Fifth Amendment concerns with that provision?
No, Senator.
Okay, on the last line of the page, I just think there's an extra word in there, except. Maybe I'm reading wrong, please correct me if I'm misreading it, but if there's an extra word in there.
Where is that, Senator?
The word except on page 2, line 36.
Okay, I'll give you this assurance. Bill makes it out of here, we'll amend it, but it'll be in the process.
Okay.
Thank you for catching that.
Yes, sir. On page 3, subsection E, starting on line 2. Document determined by the division to contain fraud or falsity by preponderance of the evidence shall be declared null. So that's unilateral authority to the division of the Secretary of State's office, correct?
any fraud we find right now, we already take, that out of the count. So it's not really adding anything new that we don't already do. If we find transcription, which would be, a whole page of the same handwriting, or if we find, that the husband and wife's signatures and handwriting matches, we already take those out.
Right. Under the current law, is there a cure possible?
We do allow, I think any of the sponsors that are here today that would testify, as we work with them, we allow them to look at what the Secretary of State staff and our temporary staff has pulled, and give them opportunity to prove, that, and we will add it back in if necessary. If we show that they prove to us that it's a good situation.
But that's not the language of this bill, is it?
That's more just procedural. It doesn't, the bill doesn't make us do that, but we have some ability to have procedures in place, and that would not change that. We would still work with the sponsor, but if they thought it was good, we could sit down with every sponsor that requests a meeting, and we let them go through, they scan, what we're working off of, to, we allow them to do that while we're still trying to verify the petitions.
But that's a practice by the Secretary of State's office.
Yes, sir.
It's not required by law.
It's not required by law.
It's in Article 5, Section 1, that the Secretary of State for a statewide petition declares a petition to be insufficient, then they should be permitted at least 30 days from the date of such notification for correction or amendment. You believe the cure is possibilities guaranteed by Article 5, Section 1 of the state constitution?
Yes, we allow for the cure if they met their signature requirements. They're allowed to turn in more signatures, and they're allowed to gather while we're verifying the currency.
Okay, do you not think that it should be required by law that a cure or an appeal should be in code rather than just a practice of the current Secretary of State, which I'm glad he does, and I'm glad his predecessors did, but his successor may not give the same indulgence.
I'm not sure that it should be in law. I don't foresee us ever changing that procedure. It's been that way since way before I started the Secretary of State's office. We go with petitions like, completely, on no one side. We just want to make sure it's done right and it's done legally. So anything we find, we give both sides. If there's an against side, we give them the same opportunity to look at the things and, as you say, cure certain signatures, or if they find fraud that we didn't find, we'll look into that as well.
Mr. Chair, I heard Senator Pate say he had a question on this bill, so I'll defer to Senator Pate. Okay, you're recognized, Senator Pate.
Thank you, Mr. Chair, and Senator Tucker, when you refer to Article 5, Section 1, would you please give me some sort of heading for the paragraph? I'm having a hard time finding it here. No, I finally found both the time I did. I'm just saying, next time we do, if you can give me a heads up on exactly what it looks, that's a long document. There it is, small print. I wish you said, Senator Hammer, and maybe the Secretary of State's office can answer this. Are we lacking a law enforcement agency to handle it? Why do we need to create a new one?
I'm going to get my answer to say be directed by the Secretary of State's office. I think part of the intent behind this is that the more that can be done, the more due diligence will provide for a more efficient method that in the event it is determined that something has been broken, unlawful, that the ability to have all that ready to present will make for a stronger case. And I would hope actually it would lead to greater prosecution. I think that giving them this capability of which they're going to have to come on to weigh in, I think they're not going to be the ones going forward to prosecute these things. They're going to be the ones that are gathering all the information. This is just helping the process. And I think what we will also do is communicate a message to the public that the seriousness of the ballot initiative process has been elevated to where if you are doing something illegal or
on, I think we say that, this division would just be investigating, they'd just be the fact finders regarding things turned into the Secretary of State's office. And then if something actually did rise to a criminal level, it would be referred out to another law enforcement agency, such as the prosecutor's office. But, you know, the Attorney General's office already has their election integrity unit. This is just, and then of course, various law enforcement agencies could investigate things, under their purview as they saw fit. This is just for the Secretary of State to be investigating things that fall underneath his or her purview. And it might be true in some of those cases that a state officer of the law or a peace officer could investigate that, but for a variety of reasons, a lot of times that might not happen.
Well, I can see why every constitutional officer might want to have their own police force. I disagree with the highway department having their own police force. And you know, if we won't have the state police, I think they could easily have a division for this or a division for that. But I would like to think that whoever is the law enforcement agency are well-trained and experienced. And so somehow when you divide that into so many different agencies and divisions, I begin to feel like you may not have skillful investigators or experienced investigators, where you might be better served to have it under a law enforcement agency that has a broader scope of work. Go ahead.
I would characterize this as these are subject matter experts that are closest to not only the offense that has occurred, but what the law says surrounding the offense that has occurred.
So we already know who they're going to be?
I don't know about that, but I think the skill set is they testified at it and they believe they have the skill set in place because they believe they can take it on under the current load, but it is the primary responsibility of the Secretary of State to be knowledgeable in all areas surrounding elections. So I really think that this is good and that they will be able to apply subject matter expertise and the knowledge of laws that rest as their primary responsibility, so that if they do turn something over, it can be handled in a more expeditious way, but also to prevent something from not being turned over to an outside agency that may come in and not have the knowledge that they have, and it could be a tool that can protect the innocents as well as we're trying to find those, who have broken the law.
I appreciate your position on that. My experience with the code board and others has been just because they have expertise on the subject matter, they do not have expertise in law enforcement.
Yes, sir, the Secretary of State is elected by the people, and if that becomes the case on the code board, it could be elected or not elected.
Thank you. So I guess I have a couple more questions. This bill kind of took a little more time for me because I've never been on the Judiciary Committee. But is it normal for us to grant jurisdiction out of state? Because in the top of page 2, in paragraph A, it says within or outside this state. Do we have jurisdiction outside the state?
Yes and no, Senator. I think what that language in there is just saying is that take a simple crime we might all be familiar with, like robbery or murder or something like that. If you murder somebody in Arkansas, in our jurisdiction, and then you ran to Alaska or Puerto Rico or Florida, we could still investigate that crime if the sheriff or the officer, if the prosecutor's office chose to do so, and try to extradite that person if we're able to find him and prove up the case. And that's what this language is getting at. We're only going to be investigating things under the jurisdiction of Arkansas, but that might involve someone outside of this state potentially.
Well, I maybe understand it when you're talking about somebody that's being charged with a crime, but this is talking about document validity, and to determine whether a document is submitted, it sounds to me like we would be going and seizing files or documents from a location, not extraditing a criminal.
Yes, sir. Yes, sir. It doesn't always have to be a crime, to your point. If somebody was, housing documents, relevant to our investigation, involving something turned into the Secretary of State's office, and if they were outside the state, as long as, we had.
So it's not unprecedented, the law enforcement agency in Arkansas can go out of state and seize documents.
No, sir.
Okay, thank you. That, I'm not familiar with that area of law. So down here in the paragraphs that deal with completing the Fifth Amendment, again, this is something I'm not familiar with. I've asked a couple of questions. People told me not to worry about it, but I won't bring it up. It says that if you plead the Fifth, we're still going to compel your testimony, but we're going to grant you automatic immunity for your testimony. So anybody we're going to prosecute, wouldn't it just be wise for them to plead the Fifth and get automatic immunity?
That, Senator, I'll say it, that's a common practice for, it's common that is something that's in the prosecutor's discretion, in all kinds of different cases, or in things involving this document validity division, the Secretary of State's office. If you're compelled, say, by a grand jury to speak, then you're going to be given immunity for that. The testimony,
So you said it's in the prosecutor's discretion, but the language out there, you're going to put it in the prosecutor's discretion. It just says it's automatic.
the language is saying that this group could compel witness attendance.
It says shall not. So in number two, the individual that is claimed his or her privilege against self-incrimination shall not be prosecuted.
What page are you on?
Page 2, down next to the last paragraph, starts with a 2. Second line is, but anyway, to start at the beginning, an individual that has claimed his or her privilege against self-incrimination shall not be prosecuted. Okay, that's not prosecutorial discretion. That says shall not be prosecuted.
It's only referring to, if you continue to read that paragraph, it's only referring to the statement given under compulsion. And it's just the standard rule across all law enforcement or prosecution that if you're compelled to testify, then that testimony isn't going to be used against you.
Okay, well, again, that's not something I'm familiar with. But I would like recognition that I had also caught a typo.
Thank you, sir. Thank you, sir. Thank you.
Senator King, you're right after the question.
So I mean, this is, so if someone has a complaint with this, law enforcement arm that you want to create this, in a petition drive, so is there like a mandate, you get a mandatory report to investigate each one of those, or will you just make a decision to say, this seems a little on the frivolous side, or the resources may be extended out somewhere else, we just don't have the time, except you're saying we just never know what we don't know. I mean, will there be some type of public report done after to say, we looked into this measure and we did not look into this measure, you may actually decide we may not even send the resources out, we look at this, what's the future? You may cover it if you get us on.
No, sir, thank you for the question. As the reporting after the fact, that might be something that is decided after the fact. Right now, it would be based on complaints from citizens or witnesses wanting to complain about something that they saw. And then, like any group, there would be that discretionary call on whether or not the juice was worth the squeeze, if you will, on if there was enough there to use resources to investigate that report. If a report was generated, I'm sure that it would be made available after the fact. That might be something that's promulgated after the fact.
This is a question I have. Would all this be voidable? At what point would it not be voidable? What would be voidable? What would not be voidable?
Open investigations would be voidable, but once the if either case closed or once the adjudicated process is ended, usually there's some time after the right to appeal or something like that, or the adjudication process is done, it could be voidable. While the investigation was ongoing, it would not be.
So looking at the flow chart of this, it could be that you might refer something to the local prosecutor if it's in a certain area, or would refer it all everything to the Pulaski County prosecutor, or could it be state and federal? Could it be federal too?
It would be referred to the local prosecutor where then you made the most sense, essentially.
So if it was in Jonesboro, then you would go refer to the local prosecutor and you're going to pass it on to him to be prosecuted for her.
Yes, sir.
You will be once again making that determination where you've got something substantial. What I'm trying to get into, back in the voter fraud days, when the denial of voter fraud days, there was just so much that was discarded and said frivolous. And actually, I quote that's Allen who said, this is just basically having to make a paragraph. This is just the way we did it. I mean, I mentioned the voter fraud registration forms. I went over there and you would see one person with the same name with 4 different signatures. You knock on their door and say, none of them are my signatures. And I can tell you, I turned all that over to that, and absolutely nothing happened. And so the Hudson Allen case, once again, there was amounts of, listen to the voter process, somebody's been on the election commission and been through a lot of things. There is a lot of that. I mean, it is. I mean, that is realistic, but what is sorting out of different things, I think that at least producing a mandatory report requirement, because then you get into, and a lot, probably unfortunately, I'm not going to vote for it, but I want those people to have a fair process. And if you get into the thing of you're deciding there needs to be some type of report to prove that even though this measure may be against what the Secretary of State might not want, we still did our diligence. So, I probably overhauled time for this. I think that mandatory reports, the voidable aspect, you're certain that every step in the process that you were doing to look into something will be voidable, or maybe. Because it's a criminal investigation at some point, and then that gets into another area.
Once the investigation was complete, it would be voidable. Or if charges were brought by some prosecutor somewhere, it would probably be the end of that adjudication process. Then it could be, once the case was closed, it would be voidable. But the Secretary of State also, in his or her discretion, could mandate a rule that at some point, once the investigation was done, the report be publicized in some form as well.
So, so let's say I'm seeing that there's fraudulent signature gathering in Carolina. I call you on that, and then you say, okay, we've got this report, and I give you some examples, like I gave the fraudulent voter registration, some signatures that. So at that point in time, when I give that to you, and that correspondence with you, would that be voidable right there at the start, or would that not be voidable?
There are protections that can be put in place for citizens or anonymous complaints, if that's your question, Senator. But essentially, the answer is we could protect people who reported us to initiate an investigation.
Yeah, but it also involves abuse. I'm just saying, just right now, if I called you and I said 17 fraudulent signature gathering here that I have with one person for 6 people, different signatures, like I gave you, I call you and you email or have some type of correspondence with your law enforcement arm, and you look at it. And then that's a week later, and I call you a week later to see your correspondence with them. Would a week after that call, and I turn over actual documents to you, I did the state election, would a week later that be?
I'm not sure I understand the question, Senator. If it's an open investigation, then people would be able to get it.
Okay. That's
Thanks, Senator.
Chair, I want to get the public testimony on this. I've got a few more questions. And I appreciate your relevance and of course, thank you, Senator, and your relevance as well. Under the current law, bad signatures, if you determine signatures bad for any reason, it already gets tossed correct. Under the current law, you're also required by law to notify the prosecutor if fraud is taking place on signature.
Yes, I mean, a lot of times if it's, possibly like a canvasser, we probably would defer to the general counsel or Secretary of State's office to send that on to the prosecutors. But we do, as far as the elections division, we do cull those signatures.
Right.
Yes, I don't have any teeth to go past that. We're just finding the documentation that, if it's a transcription or if it's, we would, and we're not signature experts, so we do cull those. And like I said, when we give the sponsor time to turn those back into us, but we refer that on to our own legal division if they're going to refer to prosecution.
As far as the teeth goes, you are required by law to notify prosecutor even if they're strong.
Yes, and in the past, like I said, we've turned it over to the legal division, and to my knowledge, most of the time, it's been done, so I think that's what these laws are, is just give us a little more teeth and a little more description of what would be, how it would be passed on for that investigative division.
And I know that you said you notify the petition sponsor of signatures are correct, but that's not required by law, that's a practice, correct?
Yes, sir, it's just a practice that we deem to be fair to the signature sponsor. Even if there's a bad actor as one of your canvassers, and then something that might seem like valid or fraud, we feel it, it's incumbent upon us to give that sponsor time to answer to that. We don't just automatically say it comes from the sponsor down.
Is there any notice to the voters whose signature is being tossed?
No, sir, there's no.
That person's being disenfranchised in a way if they're a real person.
And I say that honestly, like, at this point, if they call, we'll look it up for them, but we might even have close to, 400,000 or 500,000 signatures. And we just have not really had the office staff to send out those kind of letters. By the time we're going to court, getting it on a ballot, and then getting through 3 or 4 ballot initiatives, we just haven't had the time. But if the voter initiates it and wants to know if they're counted, we will look them up and make sure that they know they were counted or not counted and why.
Are these going to be certified police officers, or what's going to be the training that they
The document validity division is going to be made up of current existing staff of the Secretary of State's office. It's a law enforcement agency in that if an investigation is ongoing, if they're investigating a potential crime, it's not necessarily going to be made up of all certified, peace officers with the state of Arkansas. If there was some type of police action that was required, then it would most likely be referred to another law enforcement agency as laid out in the statute or a prosecutor's office.
Well, similar to, I genuinely I don't understand the timeline of how this works. So, under subdivision J1 on line 28, the canvasser shall file a true affidavit. Is this before or after they gather signatures?
It is after they've gathered signatures.
Okay. So then, starting on page 2, line 3, subdivision K, the canvasser shall not collect additional signatures unless the Secretary of State determines that the sponsor is eligible for an amendment. Under the current law, while you were waiting to determine whether you have what you need, you can still gather signatures, correct?
The battery.
That's a good question.
Yes, sir, Senator Tucker, it is allowed now that while they're waiting to see if they need to cure, they are still collecting signatures.
this change that? I'm just trying to understand, I genuinely don't understand. Would it change the fact that you can still gather signatures while you're awaiting the cure? Because this says that the canvasser shall not collect additional signatures until the sponsor, until the Secretary of State determines whether the sponsor is eligible for an amendment.
Once this affidavit would be a final affidavit on behalf of the canvasser, so they would wait until all their signatures are collected and then sign this and turn it in. And once that had been done, then they would be able to collect signatures.
It would not.
That's right. Yes,
So
sir.
that's a change from the current law.
Well, right now,
Yeah, it changes, I think that if the canvasser, if I'm reading that right, if the canvasser's affidavit, needs an amendment, that would prevent them from collecting additional signatures.
I don't think that's what it says, and maybe I'm just reading. But I think it says that the canvasser cannot collect additional signatures until the Secretary of State determines that the sponsor, not the canvasser, that the sponsor of the initiative petition or referendum petition is eligible for an amendment. An amendment being the technical word for cure on the Article 5, Section 1.
I don't think that doesn't change the current law because a sponsor could be eligible for a cure period. Currently, this is only regulating one individual canvasser after they turn in all their.
But under the current law, that individual canvasser could continue to gather signatures pending on a potential cure.
Potentially, yes.
Yeah, so it does change the current law.
In that regard, yes, it does.
Senator Tillman. This is a similar question that I had on the number, but basically, this says that the Secretary of State finds about preponderance of the evidence that a canvasser has violated Arkansas law. Then the signatures gathered by that canvasser won't be counted, right? So is there any recourse for the canvasser, the petition sponsor, the voters whose signatures got lost, any right of appeal, or it's just a unilateral decision without a trial or hearing?
They would have the same rights that currently exist. So if they disagree, then they could, appeal that.
And again, those rights exist by practice, not by obligation. As a courtesy, it exists as a courtesy in practice by the Secretary of State, but there's no legal obligation for the Secretary of State to do that.
Well, I think in practice it's done. Also, I do believe you could file suit in Arkansas courts if you wanted to as well.
Okay. All right, two more questions. Back to the big picture, particular bills. We established that the purpose of these is to make sure that every signature that's placed for something that's going to be on the ballot has integrity. There are two types of measures that get issued, things that get placed on ballots by signatures. One are ballot measures for referendums. The other is candidates. You can be on the ballot as a candidate by gathering signatures. So my question is, why are we not imposing all these same requirements for candidates to be on the ballot that we are for ballot measures?
I think this is tailored to address one particular aspect. And if you'd like to run legislation on another, we'll have a sidebar conversation about that.
Okay. Last question. All 6 of these bills have emergency clauses. Correct?
Please, correct, yes.
And where emergency clauses are dealt with in the state constitution is Article 5, Section 1. Correct?
Run that back again, I think here, I'm sorry.
Where emergency clauses are addressed in the state constitution is in Article 5, Section 1. Right?
That's correct.
And the reason for that is because if a legislative bill has an emergency clause on it, it affects the people's ability to make a referendum on that bill. Does it not? So in my view, emergency clauses on bills that affect the people's ability to put a referendum on that bill should have even more scrutiny than a typical emergency clause. So my question is, do you think that these matters are so urgent that one, they should go into effect immediately? Number two, even though they're going to affect the people's ability to put a referendum on these bills, we should inhibit their ability to put a referendum on these particular bills by putting an emergency clause. Is the emergency that intense?
He can join in to add to what I'm about to say in answer to your question, but I think that because of what we've experienced that has brought the necessity of these bills to address, I think that having the emergency clause on there will make it getting this done. I would also say that as an emergency clause, correct me if I'm wrong, that portion would have to be voted on separately with these bills making it through chamber. That concern that you have, that is a concern shared by the majority, that could be addressed at that point.
Thank you, Senator Hammer, for answering my questions.
Thanks for asking.
Thank you, sir.
All right, are there any more questions for the committee? All right. Seeing no more questions, we do have still this time to speak more against this bill, so we're going to start with the order which Senator Hammer presented them. So we'll start with Senate Bill 10. For the second time, I see several names that are signed up to speak on multiple bills, so if you all just want to encompass, your comments, one time, that would be great, but that's why people sign up here. So with that, we're going to start with Mr. Jake Gavin speaking against Senate Bill 210. And Mr. Kevin, I'm going to ask this Senator by speaking, if you wouldn't mind, just so we can keep these, comments straight to the record, the specific bill which you're speaking for, and so you've set the comments for each recall for all bills.
So I understand you want me to speak on 212.
Senate Bill 210, but since I see you signed to speak on our bills.
I signed up to speak on 210 and 212.
Okay, so I'm going to let you speak to both.
Okay.
Yeah, and you'll just let us know when you're starting with 212.
Absolutely.
Okay, perfect. So you're right up to speak with 210 and then eventually 212.
Okay, yes, sir. Jimmy Cameron, Arkansas First Citizen, but I'm here to represent myself as a citizen. 210 is really disturbing. Now I read a canvasser normally accepts a signature when the person signing the petition has not read the ballot title of the petition in the presence of the canvasser, or the ballot title of the petition has not been read aloud to the person in the presence of the canvasser. My question is, what gives the legislature to right to mandate that I have to read something to sign it? That's my choice. Whether you think it's prudent or not, really not your business. We heard a lot about that in the forum stuff, right? And how important it is to that signature and the value that Senator Hammer puts on it, and I'm not disagreeing with him. So if that's the case, are we now going to expand this and make it onto the ballot box? Or when I go to vote, exercise my right to vote, and there's an amendment or initiated act on the ballot, are you going to eventually require that I have to read that and that the poll watcher has to verify that I read it, and if I don't, I'm not allowed to vote? That's where this is going. This is to the extreme. Are you going to mandate? Are we to the point now that we're going to say, okay, now it's not just stuff that we read it. Now we're going to mandate that you take a test on it. And we're going to score you on that before you're allowed to sign a petition. And we're gonna take it, you're gonna have to take a test before you're allowed to vote. Because that's where this sounds like it's going. On 212, because I'm gonna try to be brief because I know so many people are here. On 212, when you create a law enforcement division, okay, to try to convince people that you're gonna create a division, a new division of law enforcement, and it's not gonna cost anything anymore than what the Secretary of State's office budget is now. That makes no logic whatsoever. That's gonna be a hard sell, because you can say that, and I said, well, right now, we're not gonna incur any expense, but then I'm gonna wait for you to come back to the next budget season. And then we're gonna see what the Secretary of State asks for. There's no way you're gonna create a division, an entire new division in government that's not gonna cost the taxpayers more money. The second thing is, if you're for growing government, raise your hand. Because this grows government. Any way you cut it. Now, let's go ahead to another deal. Let's talk about the law enforcement, okay? In the criminal laws in our country, here's what we have. We have law enforcement. One of my sons is a police officer, the other's a firefighter. So I'm absolutely pro law enforcement. But you have a law enforcement division that investigates. Okay, they turn that file over to a prosecutor. Prosecutor decides to charge. At that point, we go to a court with a judge and a jury. That's the way it's supposed to operate, right? The way this is drawn up, this division in the Secretary of State's office just became law enforcement, prosecutor, judge, and jury. Because they can null and void at their discretion. And when you null and void my signatures or somebody's efforts, and you do it without due process, then we have a problem. And I'll finish with this, and this is strong language, but Clint Lancaster wrote an article in Arkansas First where he described this as a Gestapo. That's what it sounds like to me. That's what it sounds like to me, and I think it sounds the way to the public. And I hope today what we're going to do is like we did in Floyd. Well, I hope we're going to, Senator Johnson wants to us in this state agency committee that you guys are putting forth a product for the people. Okay? The people that are here today to tell you they don't want your product. They don't want your product. And this is, to me, is nothing more than an attempt to undercut the citizens' rights in the Arkansas State Constitution. And they're here to stand against it. And with that, I'll be happy to take any questions.
Thank you, Mr. Captain. Members, are there any questions? Seeing no questions, thank you for your testimony.
Thank you, sir.
All right, next up, speaking for, we got Ms. Vicki Parker. Ms. Parker, if you'll introduce yourself and tell us either whether you're representing yourself and us, these speak for a couple, so you're recognized as the same as Mr. Captain. We're going to start with Bill 210 and any others you decide to speak on. You'll just reference whenever you get your comments on this.
Okay, thank you. I'm Vicki Parker with Arkansas Pregnancy Network and as a private citizen. What I testify today is me and across the state of Arkansas during the abortion amendment canvassing, what we witnessed. I'm going to start with, I believe, what you have in your hand right now. This was for the AG office, Garden has it, and it's a letter for to whom I may concern. And it's a pastor that testified to what happened to him outside of a business in Northwest Arkansas when he was talked to about signing an amendment for the, I think it was the female diapers and for feminine products. It was a teenage girl, which we know was wrong. And asking that the amendment was told that since he couldn't see the amendment and he asked to see it, to read it before he signed it, and he was told at that point that it wasn't written yet, that they got the signatures first, and then they would write it. And of course, we all know that that's wrong. So
So that's the first one, that one was sent to the AG office, that affidavit. And then conversations with other owners at the Olive One, was a petition about, that it had to do with allowing women who wanted abortion because of rape and incest to be able to discuss it with the health provider and make a decision. She also mentioned that we allow abortion in case of fetal abnormality and ectopic pregnancy, because of the life of the mother. And so therefore she didn't go as far as that. The last one that you can see there is a picture, and this was at the Olive One. And this is a table with the petition, with all the petition footboards sitting there, and there's nobody inside. And we also have the days later. So this is where the integrity is very important for this process, whether you be a citizen for or against any particular amendment for that matter. I will tell you that had we not been out on the streets with these people during this thing, I can tell you none of this would have been told, because no one would have known. But because we were standing out there head to head, line to line, can't just standing there in peace, not in an argument, just standing there in peace of it. But we overheard, when you can keep your mouth shut and you just listen and you can hear what's going on around you. So what we heard was that it was for reproductive rights. What we saw was that they were not asked every time if they wanted to read the amendment. I always, and across the state, we had the actual amendment in our hand. I had copies of it to hand to people to say, if you're not sure that this is what you want to read, to sign, or if you haven't read it, please take this and read it, and then you can come back and sign it. If that's what you want to do, but understand that's what it is. Then I had an attorney stand side by side and tell me that I could not say to people that without limitation meant without limitation, because that's not what it means. And I said, well, that's strange, because in the dictionary it says that, and Google it says that. So I think the evidence was there as well, but he continuously tried to shut me down. And again, told the people that he was talking to that that I was not an attorney, and in which I said, we don't have to be an attorney to be able to read and understand. Now, the common person doesn't always understand these bills. It takes a while sometimes to be able to read these. The other one is in El Dorado. I was contacted that there was two women sitting on the end of a table. I mean, not a table, but a truck. And they had two teenage boys walking the Walmart parking lot, and they wanted to know, asking for the abortion to be signed. And so, and of course, we know that that's illegal. But had nobody been there to see it, we wouldn't know about that. So that's important, that the integrity of the process has to be kept. There has to be boundaries. There has to be legal things that happen within that. Canvassers all over the state were telling people that that they could sign more than one time, and especially toward the end of it, they would come up and they would say, "Oh no, I've already signed it." They said, "Well, you can sign it again. You can sign it multiple times." That was witnessed by people all across the state. And again, I say that had we not been there, on any given amendment that you might bring up, any given amendment, the integrity of it is there's not always going to be people out there in opposition of it. There's not going to be people standing there to hear what is being said. So to close, what I say is, without solid representation, without solid boundaries, we humans are going to fuzz that line every time. We're gonna cross it. Depends on how passionate we are about what we're either against or for, and so it just needs boundaries put up, and those boundaries, I do feel like for these bills, have been appropriated here. I hope that y'all will help people, because a lot of people didn't understand the language, and they didn't read it, and they weren't asked to read it. I stood toe-to-toe with the lady, and she said that what I had in my hand was, there was no way to know that that was true, and I said, okay. I told the person that she was trying to get to sign, then take my bill and you flip yours over, you do have it, right? Flip it over and let him read both. I don't have a problem putting mine against, because I printed it from the same place you got yours. So this was the kind of things that actually happened out there on the line. And I close with that, I thank you.
All right, thank you, Ms. Parker, for your comments. Mr. Payton, you're recognized for a question.
Thank you, Mr. Chair. Thanks for being here. And a question came to me that I might have posed to Senator Hammer or Secretary of State's office or anybody, but you've been on the front lines. I don't know if you were paid or volunteer, but maybe somebody else come to the table can answer this. Are the paid, I was told that we can't really differentiate in the law as to whether they're paid or volunteer canvassers. But are the paid canvassers paid per signature or per hour, or do you know?
I don't know if they're paid per signature. We had a testimony coming up where they were paid. And then if there was a skirmish or a agitation, that they would get $500 for the day.
So you mentioned.
But we were, all of us were not served.
So you mentioned the canvassers would say it's okay, you can sign it twice.
Yes.
That's when the question came to my mind, well, all they care about is getting another signature,
Yes.
is getting paid per signature.
Yeah.
But anyway, maybe somebody else coming up can speak to that, thank you.
Yeah.
Senator Carter, you're recognized for a question.
Thank you, Mr. Chair. With your indulgence, Mr. Chair, I can tell you, Senator Payton, it's illegal to get paid per signature. Yes, sir. So when you observe these things, for example, you can sign more than once, did you ever call the police?
I'm sorry, say again.
Did you ever call the police when you observed these?
The police were there.
Did you
They were
notify-
always there.
Did you notify them this was happening?
Yes, and in some cities, they would not do anything. And my city, they would say, you've got to talk to the SOS. You've got to talk to the AG office. You know, they ran us up the line. I don't know that, honestly, that they knew what to do.
And did you reach out to the Secretary of State's office?
We got the affidavits for the people that could testify to it. We got those sent up there. People that were on the line, the pregnancy center people that were standing out on the line, you know, they let their state representatives know what was going on and what we was witnessing. But there was nothing that happened throughout the whole process.
Thank you, Senator. All right, seeing no further questions, Ms. Parker, thank you for being here.
Thank you.
All right, next up, we've got Courtney Hood. Welcome, Ms. Hood, and I'm going to ask you, as I've asked those before, so your time to speak against each one of these bills. So if you've got specific comments for specific bills, you just let us know where to start. I'm going to start with Senate Bill 210, and go to Senate Bill 208, 207.
I will make it easy, and I'm against all six of these bills. And I'm against for roughly the same reason.
Okay. So if the reason is the same for each one, then I'm just going to let you proceed with your
Sure,
comments.
thank you. Thank you all. My name is Courtney Hood, and I'm a citizen. And I'm here before you today to express my strong opposition to all Senate bills 207 through 212. Each of these are eminently unnecessary. And I believe an attempt to strip Arkansans of their constitutional right to direct democracy. The current system has in place many rules for vetting citizen-led initiatives. And those rules already work. We've heard how they vet signatures and throw out fraudulent, duplicated signatures. When someone calls in about a bad actor collecting signatures, they discount all the signatures and allow a cure period for if there was a mistake. But these signatures are already vetted with the current rules. And we currently aren't processing any criminals, or if we aren't bringing any criminal charges to bad actors currently, why add more rules in which we probably won't prosecute? I believe the only reason for SB 207 and 212 to exist is to make it harder for we the people to have a voice in our own government. Now, Senator Hammer is also conveniently running for Secretary of State and has introduced these bills as a poison pill designed to kill citizen-led initiatives. These bills intend to intimidate voters, create unnecessary hurdles, drown petition efforts in needless red tape, and are a transparent power grab. If Senator Hammer gets his way, future initiatives will die before they ever even hit the ballot. I urge you to reject these bills and uphold Arkansans' right to direct democracy. That was what I wrote. I have a couple of notes that I took as listening to people's testimonies. Just a random question. If I go to a place where there have petitions available to sign, like I did in Garland County, I went to the Hot Springs Library last year to sign a number of petitions. If I have to now listen to someone read the entire petition to me, and I'm a member of the deaf community, are we making sure that all canvassers are required to know ASL or speak other languages? Just throwing that out there. I think these create unnecessary hurdles to a problem that doesn't really exist. Like, there already are so many checks and balances to making sure that massive fraud is not put in place and that initiatives that are fraudulently signed don't end up on the ballot. And then it's on the ballot where it has to pass a vote anyway. So that's the end of my comments. Thank you very much.
Thank you, Ms. Hood. Are there any questions from the committee? Right, seeing no questions, thank you. Take a moment. Thank you. Next up, we have Ms. Minnie Curry speaking for. Ms. Curry. If you'll just introduce yourself and if you're representing, speaking for yourself or for any specific organization, if you can clarify that as well.
I'm Nikki Curry. I'm out of Bradford County. I'm the director of Hope Place in Warren. And what I'm going to speak about is what I personally witnessed. We were notified that canvassers were in our area, and so myself and other team members went out and we saw some of the Dollar General, 2 young females, and then had a table set up. And so we got out with our signs, our decline to sign signs. So we were approached very quickly, a blonde-headed woman that was screaming and having her finger in our face, yelling, "You want women to die. You know nothing about babies and women's health in Arkansas." And so my team member just told her, "Have a blessed day," and we went and stood on the opposite side of the door of the store, just holding our signs peacefully. We were not there for an argument. We wanted people to know what they were signing, but yet we weren't pushy about it. So a lot of people would come up and they would say, "You want to sign our petitions? You want to sign our petitions?" And I'm like, "What's it about?" Well, it's about women's health, getting free diapers and tampons, marijuana, and a casino. And they're like, "Well, what about that?" And so they never showed them at that site. They were not shown any amendment other than the casino. And there was a few people that asked exactly what is that. And so we had several other people that were around town. The same person that screamed in a team member's face locked up one of my team members in with her vehicle at the laundromat. They were very aggressive, and they were trying to provoke an altercation. So we realized why, as we started, we spent a lot of time with these young ladies, and we tried to get to know them and understand, okay, well, what would make you spend your day collecting signatures on these petitions? And we were told they were there for the money. One of them didn't even believe in abortions at all. They were like, well, wouldn't you come out here for $50? And I was like, it's July 2nd, probably not. And they were like, well, if we have an altercation like in Hamburg, we get $500 each. And I was like, well, why would you want to be in an altercation of this? I was like, why are you so passionate about killing babies? Like, explain that to me. And we had a really good conversation. They weren't rude. They were passionate about what they felt, but yet sometimes they didn't know exactly why they were there or things like that. It was a little bit confusing to me. So what I witnessed is them giving their opinion on the abortion and marijuana amendment. Like I said earlier, it was not shown, it was not offered. They could not answer questions. You'll hear later from a pastor that was there that he asked questions, and I witnessed that he didn't get the answers. And they kept just going back and forth on their opinions and women's health, diapers, and tampons. And again, the casino, I did see them offer that amendment to be read like 3 or 4 times. They tried to rush people into signing things. There were several Hispanics, and they weren't able to speak Spanish. We have a very large Hispanic population down there. And so they let people sign without even asking for an ID, and after they signed, they're like, oh, you are registered to vote here, aren't you? And so, like, that was concerning to me. They were young, so, I understand that. I just feel like, especially with the younger ones, they definitely need some serious training before they go and do something like that. You should have a copy of my team members' voluntary statement. It goes in line basically with the same thing that I've testified, and it's notarized. So it looks like this.
Thank you. Members, are there any questions for the committee? Seeing that, Ms. Parker, thank you. Testimony, thank you. Next up, speaking against, we've got Ms. Jen Waymack Jennifer. Jennifer, I just the same thing as others. I see you signing on several. So if there's any specific comments on specific bills, and then if you want to tap that, can you turn that off right next to that? Thank you. And then if you represent yourself or a specific organization.
Yes. So I am Jen Stanford. I'm representing Arkansas Appleseed Organization. I'm also here in my personal capacity. I served on Arkansas Citizens for Transparency on both the drafting committee and the ballot question committee. I also carry petitions for transparency. Those are the only petitions I carry this round. They're the only petitions I've ever carried, actually. I also am an election lawyer. I've served this body in that capacity and served this committee in that capacity. And so, as such, I'm not just here testifying for Arkansas Appleseed, but in my personal and professional capacity. Respectfully, Senator Hammer, I disagree with your opinion concerning the constitutionality of this. And I do believe that there are unconstitutional provisions throughout them. That being said, in the interest of time and brevity, I don't want to go through all the details of them. If you have specific questions, I'm happy to engage in that conversation. What I'd rather do is talk generally about all of those and what my primary underlying concern is. So when we talk about the INR process, we oftentimes talk about sponsors, and the sponsors have the least rights in all of the process. If you're looking at this in terms of a constitutional approach, the Arkansas Constitution gives registered voters the right to sign these petitions. The Arkansas Constitution gives Arkansas residents the right to carry those petitions. But even more fundamental than that is our federal free speech right under the United States Constitution. When you ask a person to sign a petition, when I say please sign my petition, that is speech. It is protected under the First Amendment. It is a solicitation. And I learned a little bit about solicitations over the last year. This is the same thing as when you go to a voter and say, please vote for me. And I don't say that as a moral argument or a position, as a matter of law. The question, please sign my petition, has the same protections as the question, please vote for me. So I ask you to think about these bills in terms of holding yourselves to the same standards you're holding people. What if, before you asked someone in your church to vote for you, you had to say, I need to see your identification first? What if, before asking them to vote for you, you had to read the ballot, you had to pull it out of your back pocket, show them what office you're running for, and read through all of your opponents' names in addition to your own? These are not the sorts of restrictions we would ever put on campaign speech when we think of campaigns in terms of candidates. But under the law, issue speech is also campaign speech. It has the same protections. It should have the same protections. Because fundamentally, I think y'all know what it's like to knock on doors. And y'all know what it's like to have knocked on doors 20 years ago and to knock on doors today. It is the most fundamental grassroots speech that we have in our society today. It is one-on-one, face-to-face, citizen with citizens, reaching out because we all care about our community. The government has no business interrupting that speech. It doesn't have any business telling you that you can't ask for a vote face-to-face, and it doesn't have any business telling a citizen exercising their rights under INR that they can't ask you to sign a petition. Now, I agree that it does need to be secure. I don't believe these bills make the process more secure. I agree that the corporate influence in these is just vulnerable. I would love to see a situation where we don't have influence money in our elections that we have today. But this corporate influence exists in your candidacy and your campaigns as well. And we're not stopping that. We can't stop that. The United States Supreme Court has protected that influence. So I understand, because I feel it with you, the frustration about making sure these are secure, the frustration that the wrong people will need these. But we cannot take away the rights of the people because we're concerned about those actors who the United States Constitution protects as well. My concern is that these bills, at their core, hold people to a higher standard than themselves. And when it comes to free speech, we should celebrate individuals talking to each other about politics. We should celebrate that we had people on both sides of the abortion issue in the same place, protesting each other, communicating with each other, and being active in the process. We should not make it harder for them to interact in this. And I'm happy to take questions.
Thank you so much, Senator Tucker. You were right.
Thank you, Mr. Chair. Senator, I just have a specific question about SB 212 because I know that you also serve as a prosecuting attorney. And you may have some experience in offering immunity in exchange for testimony. So
I was a prosecutor in Pulaski County for about 5 years. The majority of that time I was a Canadian prosecutor, prosecuting homicides and violent crimes. I never once in my entire tenure offered immunity, ever. And our position, and what was the prevailing position at the time, is that immunity incentivizes people to lie. And once you grant immunity to a witness, they are no longer credible to the jury because they got something really good in exchange for what they're testifying to. So I never once gave it. I preferred to give them a tough deal, put them in the penitentiary, maybe give them 25 years instead of 30, and condition that on testimony. but I never let them off the hook for their own crimes. I will also say, and Bob's not here, so you need to double check me with Bob on this one, but I believe that immunity is within prosecutorial discretion, and prosecutorial discretion is guaranteed by the Arkansas Constitution. So for this body to enact a law that says, prosecutor, you have to grant immunity, I don't think they have to follow that. I think they can just ignore it. And I think that's the greater problem in this, because it's almost coercive, because it leads the person testifying to believe that the prosecutor is going to give them immunity, but the prosecutor is not bound to abide by that because the Constitution is not override this provision.
Thank you. Senator Hammer, you were asking a question.
In your role as a prosecutor, did you ever plea bargain down once somebody shared information with you, or they were able to take a lesser offense?
I did. I don't think I ever did for a plea. I don't think I ever plea bargained down for a lesser offense. I would plea bargain down term of years. It was always ensuring that they were in a sufficient amount of time. It was rarely, I won't say never because I had tough cases. When you're a prosecutor, your witnesses are oftentimes not willing to testify and show up. And so it was hard. The approach I took was when I did that, I just told the jury. I was the first one to tell the jury. And I was very clear with them that my witnesses had credibility issues and that they were going to be asked to judge credibility. And I just let them do their job. And they're pretty good at that. They're pretty good at that. I was also very careful to make sure I was there to corroborate that testimony. I never brought a case where I relied solely on the testimony of the defendant or someone who got an offer. You always have to corroborate that. So there are other things that you do. My only concern is I think the testimony earlier was that it's common practice amongst prosecutors to grant immunity. And it was incredibly rare in my career. I never did or saw anyone else in the office.
Thank you. Members, any other questions? Sarah Sullivan, questions.
So you kind of compared my going to the door and asking for a vote with a petition of doing that. When I would go to the door and I asked for a vote, I never got to carry that vote to the ballot box.
That's right.
So your analogy kind of plays out at some point.
It does, I understand it, but no one is challenging that vote either, right? Nobody is letting the Secretary of State come in and say, well, you know what, Senator, you didn't read them all of this stuff before they got their vote, so we're gonna take their vote.
Right, I understand that. I'm just saying you compared and you said it's very similar. Free speech is very similar, and it is.
Yes.
I agree. However, the outcome of that free speech is very different.
It is.
Okay, thank you.
Senator Tucker, you're asking a question.
Thank you, Mr. Chairman. I want to follow up on Senator Sullivan's question because it goes to a point that I made earlier, which is a mistake I think the legislature has made generally over the last decade in this process, which is conflating signature gathering process with the vote in November. When you get someone to sign your petition, that is not the same as a yes vote on a ballot in November, correct?
That's correct.
Those are two separate parts of the process.
Yes. And also, I will go on further to say that when we talk about bad actors in the petitioning process, we talk about bad sponsors. We talk about paid canvassing, we talk about people who aren't following the rules. We need to be talking about the voters who sign the petitions and the Arkansas residents who carry them. Because those are free speech guarantees as well as INR guarantees, and that's whose rights we're infringing on. We're not infringing on the sponsor's rights, we're infringing on the rights of the people.
I want to follow, he's referring to me. And this goes back to something we were talking about earlier. You might sign a petition for something to be on the ballot and then vote against it.
Yes.
And you might sign for a candidate to appear on the ballot and then vote for another candidate.
Yes.
Thank you, Senator. How would you have a question?
My apologies, I was trying to grab from the chair, sorry. The comments you made about the individual that's signing those people sign those in good faith that what has been represented to them is truthful. And yet, testimony earlier was that the Secretary of State's office is having to answer hundreds of calls of people that are wanting their name removed, which, quite honestly, I'm not sure that's allowable now, but I'll tell you, there's potential for legislation to be introduced if you want your name taken off because you've been misrepresented to, that evidence will be made possible to you. So I think it's important to emphasize that those people that sign petitions are vulnerable and that they are acting in good faith, that the person that's presenting to have the signature gathered are operating within the law. Testimony has been given that that is not the case, not 100% of the time, but significant enough that we need to address it. So I'll welcome you to give a response to that, but I just wanted to drive home the point. The people that sign are acting in 100% good faith that the person taking that signature is operating within the law. So I don't think it's fair to characterize as it was presented by you. I'll give you the opportunity to respond. Thank you.
Senator, I would just say I don't necessarily disagree with you with regard to taking your name off of the petition. I have practical concerns about how that works for the Secretary of State's office, but I think that I'd be really interested to engage in a conversation about how to make that work. It doesn't offend me at all to allow people to do that. What was interesting is I was struck by that comment about hundreds of people calling in, because that means tens and sometimes hundreds of thousands of people don't call and don't ask to have this swallowed. And that, I agree that we should protect those people who are fall victims of actors. But we also have to protect the people that did what they wanted to, and we can't assume that they were dumb, or they didn't get it, or they were misled. We have to assume voters are doing what they choose to do.
Any more questions from the committee? Oh, so, sorry, Senator King, you did have one.
We were discussing election law.
Once or twice.
So, my previous question about the previous question about the FOIA part, what's your interpretation of the FOIA? When the request was made?
I have not dug in. So the Secretary of State's office is not a law enforcement agency. I know that at some point they have had authority over law enforcement agencies. I'm not sure that the investigation is exempt from FOIA without there being a law enforcement component to that. It would kind of depend on where it's housed. And frankly, I just haven't done the research on that. I have the same question you do. I would like to go back and look at that answer and get back.
And then, as somebody's going to prosecute, talk about voter registration, is that find those people, find out there actually is a substantial, and then turn it over to a prosecutor. It takes a lot of work to do that, just to find a few. I mean, so it's substantial to get at that point, and then a prosecutor.
So it's a big job.
Prosecute the case takes a lot to prosecute.
Yes, sir. It's a big job, and it's also specialized, right? So as a prosecutor, a lot of times you're looking at just Title V, which is where the criminal code is, and all of this stuff in Title VII isn't in there, so they're not used to it, right? These are also not their specialty area. So it requires more investigation, it requires more specialization. It's always difficult for law enforcement to perform those investigations. So I do like this idea of being cooperative in that and using expertise from each of the groups. But yes, it will be a significant endeavor. I would also note that some of the determinations that are being authorized of the Secretary of State's office in these bills, such as allowing them to make a determination by a preponderance of the evidence that a certain judicial burden has been met, and then disqualify that signature on that basis, that raises a lot of red flags for me as well, constitutional red flags. These are judicial determinations typically, and we as the General Assembly can't take judicial powers and give them to the Secretary of State as an executive body. So I have some concerns there about whether or not it's defensible under the Constitution. I think we have separation of powers problems. I also I just think the courts generally are doing a pretty good job. And I know a lot of the people in here are gonna kind of roll their eyes, because of course it's shifted in recent years, but I think that our Supreme Court does its job when it comes to this. When there is a violation, we investigate it, we prosecute it, we sue, plaintiffs sue, and by and large, our Supreme Court is getting very recent decisions on these issues. And I don't think we should preemptively assume that they're not going to continue to do that.
Basically, I appreciate your comments on that and ballot, which is unfortunately, we're not even talking about problems with grassroots, doing things that would be more, this should work, but we live so far away, like I said, you don't have $3 million. There's no sense almost, it's very helpful back. I appreciate it.
Thanks, Sue.
Thanks, Sarah Tucker. Question? Thank you, Mr. Chair. Ms. Senator, you said you gathered a signature for a petition. You have experience doing this. Is the ballot measure required to be stable to the petition?
It is. The ballot measure is required to be stable to it, and I believe that there's also language that says that it's a misdemeanor on the petition itself. But I have to go back and look at our petitions to confirm that.
Yeah, is it the popular title or the ballot title or the entire measure that has to be stable?
It's both. It's all of them. They're all there.
So if you're being solicited to sign a petition, you have the right currently under law to review not just the title, but the entire measure before you sign, correct?
Yes, you do. You have the right. It's there. And I also say, as someone who carried petitions, I was not a high pressure salesperson ever. There were times when I said, hey, I have petitions here, but I waited for the person to say they wanted to talk to me. I wasn't following them around. I wasn't stopping them in parking lots. So there's places where I was invited to be. Sometimes I asked ahead of time if I could have permission to be there. I don't have to do that in every case, but I'm not a jerk. And so I like to do that. I like to interact with my community in a more positive way. And so, it's, to me, I've described this before as, I grew up in Arkansas where we took care of our neighbors, where we went to the church potlucks and we knocked on each other's door, we had an iced tea on the front porch, and when our neighbor needed something, we brought an extra. And we have moved away from that and how we communicate with each other. We have isolated each other into algorithms and text messages. And for me, taking someone a petition and just making that conversation open to them is my pastoral. This is me today telling my neighbors, we can still talk about what we disagree on, and I want to. Because you're gonna make me smarter and better and a more reasonable human if I'm listening to both these perspectives.
Senator Sullivan, you're right after.
So if you're a petitioner and someone walks up on the street and they sign you think it's their name, but they sign someone else's name, what projections are there for an individual who had their name signed without their agreement?
Well, I think the verification process is probably going to resolve that. It's probably going to show that.
Well, probably, yes.
I understand.
Okay.
It's not perfect, right? But also, someone could theoretically have a counterfeit license when they come into that. You're never going to prevent all of criminal acts.
I'm just asking you, so you really, that happened?
I don't know. I did not see it happen. I don't have a reason to look at it happen in my presence. I'm not familiar with specific allegations on that particular instance.
So also, if we have petitioners who are allowing multiple signatures, so I'm going to sign up for myself and my mom, my cousin, my aunt, and I'm going to sign 4 or 5 signatures. Is that illegal now?
That is illegal. I can tell you, I have no knowledge of that actually happening, but I do have knowledge of I trained canvassers on our measures. In that training, we specifically were very careful to tell them no.
I appreciate it. That's a good thing. I appreciate that. But the fact is, right now, if you have to show an ID, it's going to prevent the petitioner from allowing multiple signatures.
No, because you can't require the canvasser to deny the person their right to sign. What you can require the petitioner to do is to review these ahead of time and to look at them and to communicate with the Secretary of State about them. But this bill does not, or can it require the canvasser to say, no, you can't sign. Does it say that? So no, I don't think it does neither.
Thank you.
Thank you, Senator. Senator Hammer.
A simple yes or no will be fine with me.
That's hard, Senator.
Yes. Make it easy. You're sitting here saying that you believe these bills are unconstitutional, yet the Attorney General of the state of Arkansas and staff have reviewed them and said they believe they are and that they can defend them and win. Do you agree or disagree with the Attorney General's position on these bills?
I disagree, and I prefer to elaborate if you let me.
Chair's discretion.
3 points. Of course, he's gonna represent you because that's his job. That's what he's got to do. The Supreme Court does not work for him, and sometimes he's wrong.
I'll take that as your answer, but there was no merit as far as the reason why. And I understand that you get 2 attorneys, 2 preachers, 2 legislators in the room. You're not always going to agree. But I put full faith and confidence in our Attorney General that he would not put himself or staff in a position or the office in a position for these. And thank you.
Thank you, Senator. Senator Dawson.
Thank you, Mr. Chair. Senator, you collected signatures, as you stated, it's trained canvassers on how to collect all these things and what you carry. I think my question is somewhat simple. It's been discussed here today that a signature, or someone who signs, rather than someone who's signing, is in essence sponsoring legislation. I was the big sponsor in this case, Senator Hammer sponsoring this legislation, his name is at the top. Is there anything on the notification form that notifies the signature or the signer that they are in essence sponsoring whatever the measure is that is being petitioned, and that their name will be public once those signatures are turned in? Because I believe all those are equiliable.
They are equitable, and it's an interesting question. So practically speaking, I mean, the short answer to your question is no, that's not a direct discussion. I mean, you don't call them their sponsor. As a matter of process, they're not the sponsor. The signer is not. As a matter of process, and the language we use in the process, the sponsor is the ballot question committee and voters put it forward. So yes, there's a certain endorsement or sponsorship by their signing, I suppose. I think that's a fair assessment, but it's not a part of the discussion. There was never, to my knowledge, I never noticed any confusion about the signer's part of the process. Like the questions they had for me were about transparency, were about the act versus the amendment, were about whether this was a for or against thing. The questions were never about does this mean I'm sponsoring or endorsing this? That just didn't come up. I did have questions about FOIA. I did tell them it was FOIA-able, and obviously I didn't remember, but I don't think that's required. I'm not sure whether it's on the content itself.
I was just curious about that.
To my knowledge, it's not on there. I could be wrong. I don't know whether.
Are there any more questions? All right, stand and change your testimony. Please. Members, I would say that the Alabama Constitution, the rules require us to be on board for session in 45 minutes. So it is the chair's plan to break for, to recess for lunch at least 1:15. And I'm not expecting that we're going to get to the vote on this bill. We've got about 4 pages. People start to speak on this bill about a third of the way through the first page. So, well, the chair will be happy to entertain a motion. Can I make a motion from the chair's secretary?
I'll move that we end debate at 5 after and move to a vote.
Got a motion from Senator Payne. Let's see a second. Second, Senator Sullivan. Discussion on the motion. Tucker, discussion.
Thank you, Mr. Chair. As a pragmatic concern, I understand the need that we can't be here all day and night. however, a lot of people have come here to testify for and against him. And I think it would be better if the first thing that happened would be to limit the amount of time each person can testify rather than just cut the debate off at a particular time. Because we know a lot of people who came just won't be able to be heard at all if we cut testimony off at a particular point. I think it's better to have everyone have the opportunity to testify, even if it's for a limited amount of time, than to not testify at all.
Is that for the substitute motion, Senator?
Sure. Yes, sir, Mr. Chair.
I'll second this up.
All right, so you have time frames.
3 minutes.
3 minutes, 3 minutes. Does that include questions or just for the testimony?
Not including questions.
Okay. Per person?
Per person.
Okay. Pretty much per person, not including questions. Senator Dawson, discussion on that?
Yes, I guess so. Just question to the chair, how many, you said pages, but how many people are signed up?
I'm trying to go off and mark off who's gone through, who's signed up on multiple bills. So I have five full pages, I just kind of estimated it off.
Well, I guess I'm asking questions. The estimate, are we talking about 15 people or are we talking about 50?
Oh, closer to 50.
Closer to 50, so 3 minutes per person would be minimum 3 hours. We're not going to get quite there. I don't know if you want to reduce that to 2 hours or an hour worth of just a total time frame.
Do we have Senator Clark, would you be open to amending your substitute motion?
Senator Clark's got the flu, Senator Clark, but,
You remind me, this is also, per bill, so I've got people that are not signed up to speak on multiple, just on a specific bill, we haven't gotten to, so.
I'll just say, Senator Dawson can make a substitute for the substitute.
Since we were talking about 115 before the chair, I guess make a substitute that we limit the debate to 30 minutes total. And then,
I remind you that we are still on Senate Bill 210, although we've got members, that are,
so is it,
speaking to various bills, but we've got several that are not, that are just not speaking on one.
okay, so we're gonna vote on one bill only, I guess.
Well, unless we're gonna have a motion to take them all up and we vote on all 6.
Okay, so we're discussing Senate Bill 212 specifically.
Well, we are discussing, the first thing is we're starting to speak on Senate Bill 210. But in the effort of brevity, Senator Dawson, I've asked members of the House to speak on multiple bills to bring their comments on all of the bills on the agenda,
I'll withdraw my motion and let people continue discussing Senator Tucker's motion.
Senator Payton, you're recognized.
I'll make a substitute motion that we limit the debate to 3 minutes per person and that we stop debate at 10 minutes after 1 o'clock and move to a vote on all 6 bills.
All right. Is there a second? So, Senator Payton, we can limit it to 3 minutes per person on either side, and then 110, we can make a motion for immediate consideration on each, on these 6 bills.
There you go. That's the motion that I'm doing.
Okay, so we got a motion from Senator Payton, we have a second from Senator Hammer. Discussion on the motion? Okay, not available. All right, all in favor, say aye.
Aye.
Opposed? All right. Motion carries. All right, so next up, we've got Melissa Robbins speaking for. Robbins. So we're going to take them in order which Senator Hammer presented us. So we're going to start with Senate Bill 210, go to Senate Bill 208. So we're going to just 1 minute. You just want to run down, Senator? Or you run down? Yeah, there's 6, so I'm just going to go through them. Yeah, we're out of sequence. Yeah, I'm going to just. Okay. So start with Senate Bill 210 first. Senate Bill 208. Will be second. Good. Okay. Perfect. All right, Mr. Roberts.
Mr. Chairman, question. Go on. But is there gonna be ample time for and against?
I mean, we keep, yeah,
There,
I don't want to keep this going.
plenty of people to speak for, right?
Yeah, we've got people to speak for, yeah, sorry, yeah. I mean, we're running out of that time, though. All right. Mr. Roberts, I think we're ready for you to introduce yourself and tell us who you're with, and you can recognize and proceed with your thoughts. You're speaking for the bills.
I am speaking for Bill 210, specifically because I experienced really talking about one of the other ones. I'm the director of Full Place Fordyce, and I'm here as a citizen as well. I first encountered the canvassers in our local grocery store parking lot. They were out, and I had the time to be able to share my opposing viewpoint of one of the amendments, ballot initiatives proposed. And so while I was out there, the canvasser approached one of my neighbors and, hey, do you want to sign some of these initiatives? And of course, my neighbor was like, well, sure, let me see them. And the canvasser had 5 or 6 different clipboards in her arm to share, and it was one after the other. There was no explanation. Just as she was about to begin handing things to my neighbor, a police officer was called on us for breaking the city ordinance, leaving the parking lot. So she was talking with the police officer. He was trying to get clarity, make sure no one else was in town that needed to be notified of the city ordinance. She lied, saying she was by herself, but I had that moment while she was speaking with the police officer to speak with my neighbor, and I asked her, I said, hey, if you're not for this, please don't sign it. And that's all I said, and after the canvasser was done speaking to the police officer, my neighbor asked us if there was any other clipboards, as the canvasser had handed them to her, and the only one left was the one that I was advocating against, and my neighbor chose not to sign that. And I wonder what would have happened had I not been there to say something, because it was one clipboard after another that she was signing, not reading anything. And I think for the integrity of the signature, for it to hold the weight that it should, because our signatures have very high importance. Every document, legal documents that we sign have very high importance, that it should be authentic. And if the person does not know what they're signing before they sign it, is it really authentic in what they're signing for? And so, and as a licensed educator, it's very important that you ask your students to read the instructions before they complete an assignment. And I think as human beings, that is just natural that we hold that standard and a standard of efficacy, and to be able to, the way that signatures are gathered and ensuring that whoever signs whatever, that they know exactly what they're signing, and that a more controversial amendment or ballot initiative is not sandwiched between the less controversial ones if they accidentally sign one that they do not support.
Thank you for your comments. So it all makes sense there. All right, other questions from members of the committee? All right, seeing none, thank you for your testimony. All right, next up we have Mr. Joey McCutcheon. Speaking for. I was just checking you, Joey. I was just. For the record, he is paying attention. Mr. McCutcheon, if you'll sit down and introduce yourself and tell us who you're speaking for yourself, and you can bring us.
Thank you, Joey McCutcheon, as a citizen and also the Arkansas Transparency and Government Group. I think there's no more important mechanisms to hold government accountable than #1, Freedom of Information Act, and also the ballot initiative process, and that's why I'm here today. We can debate all day about whether it's constitutional, but we know one thing: this hurts the people, and that's why I'm here today. I want to talk about, for a second, 210. my friends at Family Council put this document out. It says the marijuana amendment that passed in 2016 was over 10,000 words long. 10,000 words long. That's gonna hurt the people. I stood on street corners over the summer and I collected signatures. And, you know, we're gonna tell Bubba that we're gonna read him this ballot title. How long is that gonna take? And what do you think, Bubba, the Bubba that I'm familiar with, the conservative Bubba, Bubba's gonna say, I read this thing. I don't want big brother government telling me what to do. And I think that's what this is all about, big brother government interfering with the rights of the people. I think it's a solution looking for a problem. And I think when I stood on street corners and I talked to Bubba in a free dialogue back and forth, and I had to start the conversation with, oh, Bubba, I have to read this to you. Then I have to go and I have to tell Bubba that, by the way, Bubba, petition fraud under ACA 79103 is a Class A misdemeanor. And Bubba tells me, what's a Class A misdemeanor? Well, you can go to jail for it, and you can also face a $1,000 fine. I don't think Bubba's gonna like that process. And I don't think the citizens who passed this in 1910 would like that either. And I think it speaks against regular populace. The people rule. This is our process. This is our citizen legislators. And we don't need to be governed to any extent by this legislative body. And it's important. This is fundamental. This is fundamental to our republic, what we're doing here today. And it's meaningful. And then for those who think you can create the document validity division, to me that's kind of a scary title. It's kind of Orwellian to me. And for those who think that that's not going to grow government, now we're going to create.
We hit that 3-minute mark, so let's finish that.
Thank you, Senator.
All right. Are there questions from members of the committee? Not seeing that, Mr. Bishop, thank you. Next up, speaking for, we've got Mr. John Gaskin. John? Well, introduce yourself and tell us who you're speaking for. If you're speaking for yourself, you can bring us.
I'm John Gaskin. I'm the pastor of First Baptist Church in Warren, Arkansas, but I am speaking for myself today. I was going to the Dollar General in Warren, and there were 2 young ladies at a table by the door. And as I was going in, they said, would you like to sign for, we're collecting signatures for a ballot initiative on women's health? And I said, well, I have a wife and a daughter, I'm interested. And I asked them a series of questions, trying to narrow down what this was about, and they kept trying to get around it. And finally I said, so if I'm hearing you, it's not women's health, we're talking about women's choice, now we're talking about reproductive rights. I said, this is a pro-abortion initiative. And they said, oh, no, we personally don't believe in abortion. I said, so what is this? And then they said, well, we just think that this should be passed. And I said, okay, you've got me confused here. Is this something that is advancing abortion rights? And they said, well, and I said, well, I don't believe in abortion, so I'm not interested. And I thanked them for what they were doing, and I went into the store, and as I walked around, I thought, there's just something wrong about this. When I came back out, I did buy them a couple of bottles of water, because it was really hot that day. But then I just stood back and watched people coming through. They were all saying the same thing. Would you like to sign a signature here, because we're trying to get an initiative for women's health? And it was, oh yeah, and they were signing it. And they were signing it, and I thought 5 people went through, and I thought, I know my community, and I don't think that you would get 5 people in a row who would sign something if they knew that it was advancing abortion rights. And one of the people I kind of knew, and I thought, I know they definitely wouldn't. And I just thought, this is dishonest. they don't know what they're signing. When I looked at the signature sheet, it just had 90 signatures. There was nothing to tell them what they were signing. The ladies were not really forthcoming. And that's why I'd like to 210, at least having the title of the bill so that they can see what this is really about.
Thank you for your testimony. Members, are there any questions for the committee? All right. Seeing none, Mr. Casson, thank you for being here today. Next up, we've got Tobias Peoples speaking against Peoples.
Good morning, thanks for having me.
And go introduce yourself and then just tell us who you're with or represent yourself.
Yeah, my name's Tobias Peoples. I'm here on my own volition. I don't work for any special group that does this. I had to ask off work and come in because I think this is a really important issue. First off, I don't think the Secretary of State needs any more reasons to be able to pull something off of the ballot. It seems like they've had a pretty good grasp of how to do that when they want to. Senator Hammer had mentioned that he was against anything that would intimidate or mislead citizens about these ballot initiatives. And I think that these laws that are being proposed right now have an adverse effect of intimidating citizens from signing things when you tell them that if they sign it wrong, if their signature doesn't look quite right, that they are going to be committing a misdemeanor. I think it has the adverse effect of actually intimidating citizens rather than protecting them from intimidation, which I personally have never experienced signing petitions or asking for signatures. I think that all of this just makes it more expensive for the grassroots organizations who are putting forward these initiatives. No, it doesn't cost any more money to say something, but it costs a lot more time. And if you are paying canvassers, you have to pay them for more time, for less results. And if we want to have a system that works for the people, regardless of their income or their ability to fundraise, these laws stand in opposition to that. Not to mention the enhanced legal fees that that the organization may have to account for. That's all.
Thank you for your comments, Mr. Peoples. Members, are there any questions for the committee? All right, seeing no further questions, the rest of you, thank you for being here. Thank you. All right, next up, we've got Ms. Dawn Shell speaking for. Come on up. Thank you for being here. Introduce yourself, and if you're here representing yourself or any organization, please let us know.
My name is Dawn Shell, and I'm here as a citizen. And my story, I'm just going to tell you how I came about signing this and my opinion. So my husband is a pastor of a church in Swain County, and we were doing a funeral for a friend of ours, a memorial service. And afterwards, one of the ladies at the funeral said, "Hey, I've got these petitions, would you sign them?" And we were aware of one of the petitions that we had wanted to sign regarding the women's products for diapers and women's products. She said, "Well, I've got the signature sheet, I'm sorry, let me run and get it." She brought all the signature sheets in separate yellow covers. There was no initiative attached to it, all it was the signature sheet. And she started up and she said, "This one is for this," and she said, "This one is for women's health." Nothing that's told us what it was for, nothing, just, she said, women's health, women's products, this is marijuana. That was all we were told. And I signed the one that she stated was for women's health. Being a woman, I am a mother of a daughter. I'm also a grandmother raising my 2-year-old granddaughter. And so absolutely, me and my husband both signed it. Of course, we were in the midst of grieving family and trying to be with family. She called us at a time that was busy. We were not at a place where they were out doing it in public. And I went out, and as I said, I'm a mother. My husband is also a law enforcement officer and a pastor. We stay busy, and I'm often a single mother, basically married, raising my granddaughter. So I went out, and when it came on the ballot, obviously when I read it at the polls, I voted against it because of my belief. But at the time of signing the initiative, did not understand because we were not explained. There was nothing to read to tell us that. I was not aware that actually mine was on the initiative for that particular one until a friend who had gotten the FOIA called me and said, I know your stance, do you know it's on that? My name is now permanently attached to something that I do not believe in. And so it's out there on where I signed to put this on the ballot. Had I understood what I was signing, I would not have signed my name to be allowed to be put on the ballot for a vote. So I was deceived into believing that it was for just general women's health. Nothing to read that showed me what I was reading.
All right, thank you for your testimony. Members, Representative Tucker, you're going to ask for a question.
Thank you, Mr. Chair. And the ballot measure was right there where you signed, did you ask to read it before you signed?
There was no ballot measure. All it was, she went in and brought in 5 different vanilla folders with signature sheets on it, no ballot initiative. She went through her card, pulled in 5 vanilla folders that only had signature sheets.
So the ballot measure was not there when you signed?
Was not there.
That's against the law. And did you say you voted on this in November?
I did vote on it, and when I went to vote and read it and started studying more, I voted against the initiative because I did not believe in it. So I was not for it. I'm pro-life. I did not believe. And that's when we did vote against it at the time, but I would not have voted to, or signed to even have it on the ballot because that was my personal belief. And I do not want my name attached to that is now out there for freedom of information. Anybody may see my name.
Thank you.
Thank you, Senator. All right, are there any questions for this committee? All right, seeing none. Next up, we'll take Ms. Crystal Foster.
Thank you.
Ms. Foster, if you'll introduce yourself and if you're here on your behalf, you're representing the commission.
I'm Kristen Foster. I'm here on behalf of the League of Women Voters of Arkansas. A couple of concerns just in general on this. One, we know that in Arkansas people rule, and I would argue that's not just our state motto, but that it's fundamental to our identities as our teams in the office. And the way this is written is going to make it where, for the ballot initiative process, only paid canvassers rule. Because regular volunteer citizens are not going to want to subject themselves to this kind of risk, right? When you're making this, we're obviously meant to make them feel intimidated to go out and carry a petition. If you can't answer every single policy question, if you're not a policy expert, are you going to be allowed to carry these petitions at all? All you can answer is this is for or against the very basic thing. But more specifically, I want to speak to SB 212 around the document validity petition. We talked a lot about initiatives and referenda this morning, but I would argue that this also applies to voter registration applications and sets up a two-tiered system. Because right now, a voter registration application can be submitted to the Secretary of State, or it can be submitted to the county clerk. And so if it's submitted to the Secretary of State, it's now under a different level of scrutiny that it can be held to, versus if it's submitted to the county clerk. Right now, those forms when they're submitted just get shipped off to the county clerk for review. But this would change that process. And I think that the way that this is set up and the way that it is written is it will have a chilling effect on nonprofit organizations who engage in voter registration at this point. Because when I'm registering someone to vote, I don't verify their identity, I don't verify their criminal background, I don't verify their citizenship. That's the responsibility of the county clerk. But if I'm turning in forms that are found out to be invalid, it opens the entire organization up to scrutiny, to investigation, to liability, civil or criminal liability, in a way that has not been the case. And we don't have a method as volunteers or organizations out registering people to vote. We don't have a method to verify all of those things. I can't check someone's background. I can't check that their identity is correct. If somebody registers as Mickey Mouse, I have to turn that form in. But it's not on me to make sure that they're correct, right? But then this will be opening me up to that kind of scrutiny and investigation if I turn in those forms to the Secretary of State's office versus to the county clerk. I also have major concerns about the fact that we would be opening up, putting people in law enforcement positions that are not certified law enforcement officers, that are not gone through the kind of training that our law enforcement officers go through, but we will be appointing them as law enforcement officers, is very concerning. Also, just one other point to make, well, two more points to make. One, I've heard a lot about duplicate signatures when we talk in here. Secretary of State already disqualifies duplicate signatures, they're not counted twice. And lastly, last point I'll make is when we talk about why out-of-state people would be interested in this issue, why out-of-state people would call Senator Hammer and talk about it, I would also wonder why out-of-state people would donate $14 million to our governor's campaign, that there's a lot of reasons.
Thank you. Senator Payton, you're ready to propose the motion.
Thank you, Mr. Chair. And while I do appreciate the attendance and the debate and the emails and the text messages, we do have other responsibilities. And I think that it's time that we move to a vote. So I would move to pass on Senate Bill 210. I move to end the debate first.
Okay. We got it. Motion by Senator to end debate. Is there a second to that motion? Okay, got a second, Senator Hammer. All in discussion on the motion. Senator Tucker.
Again, I just want to reiterate, people came here from all over the state. We need to come back after the closed session, which I think will be brief today. I would prefer giving the people an opportunity.
I'm sorry, it's not available.
Thank you, sir.
All right. Got a motion, second. All in favor, say aye. Aye. Opposed? No. All right. Motion carries. All right, so first up, Senator Hammer, you can go to the table, we close for Senate Bill 210.
Mr. Chair, I think a lot of discussion has been had. I think enough on either side has been said that we can move to the point that I will make a motion to adopt Senate Bill 210.
All right, the motion from Senator Hammer, this is the second. Second from Senator Sullivan. All in favor, please say aye. Aye. Opposed? No. All right. Senate Bill 210 has been adopted.
Same thing, Mr. Chairman, I would move to adopt Senate Bill 208.
All right, we got a motion. Second from Senator Sullivan. All in favor, say aye. Aye. Opposed?
Nope.
All right. The bill carries. Senate Bill 207.
Mr. Chairman, same thing, I would move adopt Senate Bill 207.
Okay, we got a motion to pass from Senator Hammer. Got a second from Senator Sullivan. All in favor, say aye. Aye. Opposed? Nope. All right, Senate Bill 207, we pass. All right, Senate Bill 212.
Chair, I'm just deferring. Is it a member of the committee is calling for roll call?
Do you want a roll call?
What? How many it seems like there's five? Okay, so unless this one is here, I don't know. We might well call this one to see it's the only one I think. There's some. It seems like there's five.
Let's roll call this one. All right, we got a motion from Senator Hammer.
Senate Bill 212, motion to pass.
A motion to pass, second, Senator Sullivan, go ahead and probably do a call roll on this one.
Senator Clark. Senator Clark. Senator Hammer.
Aye.
Senator Hammer, yes. Senator Sullivan.
Aye.
Senator Sullivan, yes. Senator Tucker.
Nope.
Senator Tucker, no. Senator King.
No.
Senator King, no. Senator Dotson. Senator Dotson.
Aye.
Senator Dotson, yes. Senator Payton.
No.
Senator Payton, yes.
No.
Sorry, Senator Payton, no.
All right, so chair vote aye, but still, Senate Bill 212 does not pass.
Mr. Chair, remind me, do we need a motion to expunge vote before you brought that up for consideration?
It can be brought back up.
All right, thank you. You ready to move forward?
So Senate Bill 211.
211, motion to pass.
All right, we have a motion to pass, Senator Hammer, second by Senator Sullivan, Senate Bill 211. All in favor, say aye.
Aye.
Opposed? Senate Bill 211 passes. Moving to Senate Bill 209.
Senate Bill 209, motion to pass.
We have a motion to pass by Senator Hammer, second by Senator Sullivan. All in favor, say aye. Aye. Opposed? Senate Bill 209 passes.
Thank you, Mr. Chairman.
Members, seeing no further business on this committee, we are adjourned.
Senator Hammer, thanks for breaking these up.
Senator King, thank you. We are adjourned.
Yes, ma'am.
All right, folks, it looks like 212 is voted down. The rest of the bills could have been voted down, had a roll call vote. There's not enough, it needs 5 votes to pass out of this committee, and there's not 5 people that supported all these bills. So I don't know what's going on. Now it goes before the regular Senate. Maybe we can kill it there. These bills all need to be shot down. They're bad. Nobody wants them. But anyway, it's crowded here. I got a lot of stuff to do. Highlights will be at just the right angle. And other than that, y'all have a good day.